Good morning, Judge.
Hey, good morning. How are you?
I'm doing okay. How about you?
I am doing fine. I think we're waiting on Gordon to bring people up. I don't know if he's opened the courtroom yet.
Okay.
We have a plea now at 1 o'clock.
Okay.
What we're supposed to do right now is a few motions in this gang case. Then I think at 10 o'clock, we were going to take a plea from yesterday's calendar, and another case from yesterday's calendar has said, you know what, no trial, we want a plea. And they'll all be virtual, but that'll be at 1. And that should wrap things up. The rest of the stuff I've got is civil in the afternoon.
Okay.
Good morning, Judge.
Hi, Ms. Nelson. How are things?
I think we'll be fine today.
Good. Well, we need to get rolling or we're going to crash into other stuff I've got on the calendar.
I'm wondering about this calendar, if everyone opened their emails and read it, because this wasn't a notification calendar, it was emailed directly to them. Because it was, but
we'll see.
Hopefully they'll be here.
Yep. I emailed you back about Mr. Casillas's plea. You had the correct code section. It's right there, black and white. So if they say no again, I'm happy to reach out to send them the language if that's what they need.
Okay, well, I'm going to reach out to them one more time and see if they'll take it. I'm going to resend it with a little bit of an explanation and see if that'll work.
Great. Hopefully there's some lawyers out there. We'll find out.
We'll come to a courtroom full of people.
Yeah.
Yeah.
Good morning.
Hey, how are you?
I'm well, thanks. You?
Hey, good morning.
Good morning.
So you don't want
Hey, good morning. Are those for Mr. Johnson?
He's going out first.
He is. There are only 2 cases for Monday. Everything is. We'll talk about it. Mr. Body, did you hear from either Mr. Hoover or Ms. Warlick about today? Okay. Ms. Nelson, can you reach out to those 2 lawyers? We've got lots of people in court now, ready to go.
Yes, I'll reach out to them.
Thank you.
And yeah, just should maybe foreshadowing a little bit of what the state's position will be. Obviously make the announcement again, but as relates to the severance issues, my argument or announcement is gonna be, we're a little premature to make that determination. Because there's so many defendants who have indicated that they wanna, take pleas.
Sure.
So this.
I think it's too fluid right now, and the reality is, if there were no pleas, we wouldn't try everyone together anyway, and so there would need to be a discussion about how we break it into pieces. There's Mr. Hoover. Good morning, sir.
Morning, Your Honor.
What's up, man? Good to see you.
So just Ms. Warlick, Ms. Nelson.
Mr. Clark, the only one arguing motions there?
Okay.
No, 2, your client and Mr. Shannon. Only ones where lawyers have filed motions, although we do have 2 defendants who lost their lawyers because of conflicts or someone left. I think it was your office, Ms. Williams. Yeah, and leaving someone behind in this case. So we need a new appointment. And then the local public defender discovered a conflict. And so Rachel Gordon had to roll off as well. Deputy Gordon, is Mr. Clark here? Okay. Once Mr. Hoover gets situated, we'll bring him out. We can at least get started on that. So we're making progress. And then we'll see if we can track down Ms. Warlick.
Yes, Your Honor. Oh, sorry, yes.
He likes that.
Congratulations.
Yeah, he may not want that role. All right, Ms. Rivers, are you ready?
Yes, I am.
Great. And good morning, Ms. Harvey. We will need your help. That probably won't be till 10. I think we're supposed to be taking a plea at 10, and then we have another plea at 1. What we're going to work through right now, you're welcome to listen to, but we'll need to press you into service around 10.
Okay, thank you, Judge. Good morning.
Okay, we're going to get on the record in 25 SC 006076, State versus Clark. Good morning, Mr. Clark. Mr. Clark is represented by Mr. Hoover. Mr. Hoover has filed a motion to sever. Today is the day we set aside, or this morning is the morning we set aside to handle the pretrial motions that counsel have filed in this case with many, many defendants, and that had boiled down to 2. Mr. Clark and then Mr. Shannon's lawyer has filed a few motions to include a motion to sever. We're trying to track that attorney down, but we do have Mr. Hoover. I appreciate him getting here. He is often elsewhere in the state, and we have Mr. Clark. So what I'd like to do, Mr. Hoover, is hear you out on severance, but before I do, I want to share with you that what I may do, even after I hear you out, is say we're going to table it because there are many defendants in this case, and it could be that when the dust settles, there are only 3 defendants left, and the concerns you have, if yours is one of them, your client is one of them, the concerns you have don't apply to the 2 remaining. It's hard to know at this point, but I want to give you a chance to start to make a record on this. And you may have identified something in discovery where it really don't matter what happens with the other defendants. Mr. Clark ought to be severed from person X and Y and Z because of. So why don't you share with me your thoughts and concerns about a joint trial? Last thing I'll say, I would not try everyone together. That's not how this would play out. If there are no non-trial resolutions and we get to trial date X, well before that date, I would be calling upon the state to identify which, up to 4, it wouldn't be more than 4, which 4 defendants do you want to try first? We would go to one of the courtrooms on the first floor, and it would be a trial of those 4 defendants. And so, again, this question of severance might be solved because if Mr. Clark isn't someone who wants to resolve his case short of trial, he's not in those first 4, it could be after the trial of the 4, then he does want to resolve his case. But we ought to start thinking about if there are groupings that wouldn't work, because the state might think, great, it'll be Clark and Shannon and Byrd and Unique Jones. And you're highlighting something where Clark and Jones couldn't, not to be tried together. Okay.
Your Honor, before I start, we also filed a motion for bond on behalf of Mr. Clark on, I believe, May 19th of 2025, which hasn't been addressed either.
Well, that was a long time ago.
Yes.
Okay. And we never had a bond conversation?
So he had another attorney at first. Bond was, I think bond was denied the first one, right, by, yeah, when he first got here, he got a bond here with another attorney. It was denied. I got in later, and then when I got in, I filed the bond motion. But no, it has not been addressed since we filed it.
Okay. Well, two things about that. One, if Mr. Abadi is comfortable addressing it, I don't know that it was on his radar for today, not because it wasn't in the docket, but what Ms. Nelson teed up were the other pretrial motions. But if he's comfortable going forward with it and thinks he can get input from family members, et cetera, and if we don't get Ms. Warlick, then we'll have time to do it. So we'll do that. If not, then we will calendar it. And I apologize that it wasn't on the calendar. So we will calendar it. If it's not something we can tackle today, we'll get you to share your schedule and we'll figure out a time when we can come back exclusively for that.
Okay, thank you, Your Honor.
All right, sure.
And in regards to the severance, I was actually going to say something similar to what the court said at the beginning about which co-defendants. And to streamline this a little more, there are 10 co-defendants altogether.
Including your client.
Including my client.
So total universe of 10.
10 co-defendants and 44 charges. Now, to narrow this down for the scope that the court was already speaking about, out of the 10 co-defendants, it's my understanding that Mr. Byrd, let me back up. Mr. Clark is only being charged with the first 10 counts in the indictment. So the other 34 counts have nothing to do with him whatsoever.
Or at least he's not named in them.
Correct.
Yeah.
Well, I say it has nothing to do with whatsoever.
Okay. No, I pulled up my little chart. You're right. Mr. Clark is counts 1 through 10.
Yes.
And so there's some, like Mr. Blackwell, not to pick on anyone, but he's counts 29 through 33.
Exactly.
So Clark and Blackwell, it would be odd if the state was required to say, pick your 4 to group those two together.
Exactly.
Whereas
So-
Chambliss and Clark and Maloney
And Byrd.
and Shannon are all 1 through 10. And some of them, they're more than that, but those, looking at the chart, those 4 have the identical 10 counts.
Mr. Byrd is part of the 1 through 10 as well.
He goes on beyond 10, but yes, sir. And Mr. Marriott is 1 through 14, so he'd be there. So it looks like there are 6.
Count, yes.
Yes, 6 who overlap entirely with your client.
Exactly. So that,
Okay.
that could possibly narrow the universe.
Yep.
Or depending on what happens moving forward.
Yep.
And like I said, I'll streamline this to be quick because it's pretty straightforward in regards to Mr. Clark. Like I said, 10 co-defendants, 44 counts. He's only involved in the first 10 counts, Your Honor. And we're asking, it's a little peculiar, what we're specifically asking for. We're asking to sever Mr. Clark, and I guess because I'm asking to sever Mr. Clark, I'm asking him to sever him from all of the co-defendants that are on those charges that Mr. Clark has nothing to do with. Now, I know
He has nothing to do with Mr. Maloney as in he doesn't know him, but sever him from Mr. Blackwell, sever him from Mr. Miles Pratt.
Yes.
Because Blackwell, as I said, is 29 through 33. Miles Pratt is 11 through 14. Unique Jones is all numbers higher than 10.
correct, Mr.
Okay.
Few as well.
Okay.
And just to give a little case law behind it, Your Honor. The question before the court to consider whether or not to sever is, number one, whether the number of defendants will create confusion as to the law and evidence applicable to each. Number two, whether there is a danger that the evidence admissible against one defendant will be considered against the other despite the court's instruction. And three, whether the defenses of the defendants are antagonistic against each other. Now looking at, and that comes from Langford v. State, 295, Georgia App 590, 2009 case. Atkins v. State, 279, Georgia 424, 2005 case. Adams v. State, 264, Georgia 71, a 1994 case. And OCGA 17884, subsection A. Now, looking at the first part, the first criterion in it, which regards dealing with the number of co-defendants will create confusion. In this particular situation, Your Honor, I believe that this will 100% cause confusion when it comes to number one and number two. But when we're looking at number one, like I said, Mr. Clark is only involved in the first 10 charges, which also include Mr. Chambliss, Mr. Byrd, Mr. Maloney, Mr. Marriott, and Mr. Shannon. If we add in, or if the court allows the state to bring in, say, one of the co-defendants that has nothing to do with those first 10, then that's going to cause confusion simply because the number of the co-defendants, the number of evidence is going to come out, the number of information, this bleeds into number two, but the number of information that's going to be presented that has literally nothing to do with either that co-defendant or the information from that co-defendant has nothing to do with Mr. Clark and his co-defendants. So we say because there are 10 co-defendants altogether, and all of these 10 co-defendants aren't charged with doing all of the crimes together, that in and of itself is confusion. We're not talking about one or two co-defendants in this case. We're literally talking about 10, and some aren't even connected. Well, in my mind, or in my vision, some are not even connected. But that kind of bleeds into number two. Is there danger that evidence admissible against one defendant will be considered against the other despite the court's instructions? Now, I understand the court can give limited instructions. I've been in front of a number of judges, especially you, that have given instructions to tell the jury this particular piece of evidence can only be used for this particular co-defendant. This case is is unique from those types of cases, Your Honor. And just to give you an example, so counts 1 through 10 happened on December 29th, 2024. And that's the count. Those are the only counts that Mr. Clark is being charged with.
And they all relate to an event or collection of events on a single date.
On a single date.
Okay.
Now, the next set of counts 11 through 14, happened on December 9th, 2024. Mr. Clark is not charged with any of those.
Okay. Although it's only a day apart. He's just currently there's no allegation he's connected with the events of the preceding day.
Correct.
Okay.
Now, jump to the next group of counts 15, 16, and 17, January 22nd, 2025. When you go to the next group, counts 18 through 28, that's January 28th, 2025. Go to the next group, January 29 through 35, that's January 16th, 2025. When you go to the next group, counts 36 through 42, January 2nd, 2025. And when you go to the last two, counts 43 and 44, again, those are January 2nd, 2025 as well. So we're dealing with 5 separate, five incidents that happen on 5 separate days that Mr. Clark has no connection to whatsoever. So I think it's even more confounded when we're telling the jury, you can only focus on this for one client. But now, not only do they have to, we're telling them they have to focus on these events for specific people, but these events for specific people on a specific day that matches this co-defendant, but not 9 others. Like that becomes more problematic when it comes to a limiting instruction for jurors.
It does. It's also, it's more of a sprawl. Do you have any concerns that you think rise to the level of justifying severance, of having Mr. Clark tried alongside one or more of the individuals who are December 10th, 24 only? In other words, counts 1 through 10.
No, Your Honor.
Okay. So there you see things could evolve. But right now, you don't see a Bruton issue. You don't see, well, there's more evidence against this guy and it could be prejudicial. It is, as long as your request would be carve out those 4 co-defendants whose events Mr. Clark has no connection to.
Correct.
Okay.
And just for the record, I don't want to blanketly say no, because yes, I do see there's definitely more evidence on some co-defendants than others, but Georgia case law says just putting that alone isn't enough to get severed. So I understand.
You would not prevail if it was, gosh, and I'm making this up, but Mr. Chambliss looks a whole lot more guilty than my client. I don't want to go to trial with him.
Exactly.
You know, your guy just stayed in the car. He's just the getaway driver. Again, making this up. You know, he could be tried with the guy who then went in and beat everyone up. But you're drawing a different distinction. It's the state's not alleging a connection other than presumably they're all in the same organization. But apart from that, Mr. Clark wasn't there, wasn't involved with December 9, January, date A, B, C, D.
Exactly. Yes, Your Honor.
That makes sense.
Yep. And that's literally all we have on that.
Okay. I appreciate it.
Thank you, Judge.
And Mr. Hoover, before you came in, Mr. Abate had said, Judge, I just want to flag for you, the state's position is going to be, this isn't ripe yet. Not necessarily your motion, but the concept of severance, because there's so many moving parts and some defendants may drop away. But I don't know that Mr. Abate perceived your motion the way that you described it, which is, I'm not saying Mr. Clark should be tried solo. It's just keep the people who allegedly did things on completely separate days out of Mr. Clark's trial if Mr. Clark goes to trial.
And yes, I guess I should have made it a little more clear in the actual motion itself. And depending on how the court rules, and depending on when we move further, who comes in and who comes out, we most likely will have to file more motions in regards to Mr. Clark, in regards to what evidence comes in pertaining to the whole list of issues that will pop up.
If, for example, he was tried with Mr. Miles Pratt, where that's a completely different day.
Yes.
Okay, got it. Okay, understood. Thank you. Mr. Abadi, your thoughts about the way Mr. Hoover has articulated his severance concerns?
So I can say very simply, I don't disagree with many of the things that Mr. Hoover relayed and spoke to Your Honor about. I think it makes sense, as the court has indicated. It would not make sense to try every defendant together, as it would be one way too many defendants in one courtroom at one time, and it wouldn't be an efficient use of the court's time and counsel's time. So I don't disagree that, for example, the individuals charged in counts 1 through 10 would be tried together. I think the only outlier, and I think at this moment in time, is not necessarily right. We don't know what exactly is going to happen with the other co-defendants. Like Mr. Byrd, for example, he's charged in counts 1 through
21 and 24 through 26. So
correct.
he does overlap with Mr. Clark, but then there's that additional information. But I think that goes to Mr. Hoover's point that the initial objection wouldn't apply because they overlap, but there might then need to be some real clear limiting instructions that whatever the jury hears about events on days other than December 10th have nothing to do with Mr. Clark. And if Mr. Shannon was being tried with them, and Mr. Shannon, because their counts 1 through 10 solo. Okay. And we'd have to work through that. And it might be that counts are severed if that's the way the state wants to go forward, where they're tried together up to a point, and then we get a verdict, and then that same jury can hear more about the remaining counts, but those would only be as to Mr. Byrd or something. But I also take your point, Mr. Body, that it's so early in the process. Currently, all the defendants are still in the mix. That may not be what's happening when we're getting to that rubber meets the road of, okay, trial is August 1st. What are we going to do? And then some defendants start saying, well, what I'm going to do is get out of this mess and enter a plea.
And I can tell you from my understanding, speaking with Mr. Hiles, who was the previous counsel on this case, he has already spoken with and arranged, and it just needs to be done with counsel for Mr. Miles Pratt. So it's very likely that he will come completely out of the indictment.
Okay.
So there, and I'm sure he's not the only person who, ultimately that will occur. So
Okay.
Don't want to waste the court's time or counsel's time as it relates to this issue only because it's so fluid, as the court said.
Sure. So what I'll share with you, Mr. Clark and Mr. Hoover, is that I agree. And I would be inclined to, instead of simply saying, if no case is worked out, saying to the state, pick any 4 you want, to explain to the state that there needs to be a chronological connection or linkage, rather than counts, because I think it's the chronology that really would drive it, of the grouping you pick. Don't pick Blackwell, who's at the very end of the indictment, and Miles Pratt, who just has one segment, and say Mr. Clark, because they're only connected by the piece of paper that is the indictment and not by the way the allegations are set forth. And I'm hearing the state say, we agree, that wouldn't be, if those are the only 3 left, it might need to be 3 different trials, which isn't super efficient, but that just would be dictated by what they're charged with and how that played out. So it's a tentative yes to what you flagged, which is avoiding a trial of multiple defendants whose counts don't overlap. And then we'll just see how that flows. And then obviously we have to revisit it because there could be other concerns when we do see who's left. And again, just simplifying, if it was Chambliss, Clark, and Maloney, they're all three, 1 through 10, you might still have a severance concern once you know for sure this is the lineup. So you're not waiving anything, but I think what we'll do is table this for now, knowing that we probably won't run into your highest level concern, which is having your client go to trial with people whose counts don't overlap at all with your client. Okay?
Thank you, Your Honor.
You bet. I think I saw Ms. Warlick. Hey there, how are you? What we're going to need to do, Mr. Hoover and Mr. Clark, is pivot to her motions. But I have made a note to get Mr. Clark's bond motion on one of our next available calendars. And what I'll do is have Ms. Nelson work with your schedule, and you can decide whether it even needs to be a notice calendar. If it turns out that our second week of the trial calendar falls apart and you've got time in 10 days, then we'll do the bond hearing then. Okay?
And really quickly,
Yes, sir.
when I was looking on Odyssey this morning, I noticed that the court put this on for August trial. I have a problem with that. I am on the Carroll County case, especially said my client is charged with killing her parents and then going on TikTok and doing a bunch of stupid stuff. That has been especially said.
More stupid than killing her parents.
Yeah, unfortunately, yes, I believe so.
Okay.
But that judge especially set the trial. Ms. Williams left and I took over.
Oh, that was her case.
Yes, and
Okay.
that judge is not changing the date, so I will be going the first day of August, or August 3rd, and it's gonna take at least 6 to 7 weeks.
Sure, that will be a long trial. What that says to me is, rather than we need to move our trial date, that that would be a reason that the state wouldn't be able to include Mr. Clark in the first tranche of defendants if we get to the point where there are more than 4. If there are only 4 left, then it might be that we agree we have to pick a different date if Mr. Clark is one of those 4. And the state might say, well, we'll just go forward with 3, see how that goes, and then come back to Mr. Clark. But we're going to try to keep that date hard and fast. We have young men who are stuck in jail, and they have been for a long time. So like I know you are, I'm anxious to get it tried, but we can't try Mr. Clark's case if you can't be there.
Yes, sir.
So is the case you just described an older indictment? Because I can always specially set.
22 or 23.
Okay, this is a 25 SC, so yours doesn't even need to be specially set. It will come ahead of this one anyway. All right, thank you for flagging that. I'll get the bond motion on the calendar.
Thank you, Your Honor.
Sure. Mr. Clark, do you have any questions for me before we wrap up? Okay. So if we could get Mr. Shannon and Ms. Warlick to come on up, please.
Oh, I'm whispering. Good morning.
All right. Let's get on the record in connection with Mr. Shannon's case. It's the same indictment number, 25 SC 006076, and he is represented by Ms. Warlick, who is here. Good morning, Mr. Shannon. How you been? All right, you've been following all the things you need to follow on bond? Okay, I saw here's Ms. Singleton. Have we had any issues with Mr. Shannon?
None at all.
Okay. Mr. Shannon, you are in a similar situation as Mr. Clark in that you're charged in counts 1 through 10 in this indictment. Your situation is different in that you're out on bond, and it sounds like you have done a good job of managing that such that Ms. Singleton has nothing bad to report. We're going to talk some about motions that your attorney has filed. Ms. Warlick filed a motion to sever. And that was what we were talking about with Mr. Hoover just now, and we'll probably start with that. There's also a motion to exclude prejudicial evidence. And then finally, a demur that relates to, I think, the gang count in the indictment. And I think we'll take them in that order. Ms. Warlick, I don't remember quite when you came in the discussion that Mr. Hoover and Mr. Abate and I were having. Tell me if your concerns were about the same as Mr. Hoover's, if you heard what they were.
I did hear, Your Honor. They are the same concerns, except we do have a Bruton issue.
Okay.
Co-defendant that kind of ties the counts that Mr. Shannon charged with some of the other counts, Israel Bird, and he does implicate Mr. Shannon directly in a statement that he made to police.
Okay.
So that's how that. But if the court's position is it's a little too, and we need to table it, I understand that completely.
Okay, but it's good to know there are some Bruton markers or landmines out there. But it sounds like you agree that Mr. Shannon, who's one of those 1 through 10 or December 10th, 2024 defendants, he ought not to be paired up with for trial with, just as an example, Unique Jones, the one female co-defendant. Her counts are 15 and beyond. And so that means she's implicated in dates that are not December 10th, 2024. And so trying Mr. Shannon and Ms. Jones together would raise the same kind of concerns Mr. Hoover shared. Okay, you're adding to that, that should Mr. Byrd and Mr. Shannon be put in the same trial group, then the state would either need to not use Mr. Byrd's statement or redact some part of it or not try Mr. Byrd together with Mr. Shannon. Okay, I'm gonna hear from Mr. Abate on that in just a minute. Any other severance concerns?
That would be it. The other, I think Mr. Hoover articulated every other one of them.
Okay, and so those are adopted by you, and I think they are important ones. Some of them may not be quite ripe enough yet to say we don't need to worry about it, but you've certainly put it on the table. Mr. Abate, what do you know as the inheritor for now of the case about Mr. Byrd giving the statement that could create a Bruton issue vis-a-vis Mr. Shannon?
So I would agree with the statements of defense counsel. If the statement was to be used in full as it was made, then we would have a for sure Bruton issue.
Okay.
I have not, to be candid with the court, made the determination if I'm going to use the statement in a trial.
You might not use it at all. You might use portions where Mr. Shannon's name isn't mentioned.
Correct. And especially if I determine to use only portions, I would make sure that I obviously let defense counsel know the portions that I would use. So if there were any objections as it relates to rule of completeness or things of that nature, we could litigate those. But I would agree that if the statement's used in full, then what I would do is my suggestion would be to sever Mr. Byrd, and then we would use him in some way.
Got it. And so it might be that Mr. Shannon and Mr. Maloney and Mr. Clark, all of whom are counts 1 through 10, they could be tried together and Byrd would need to not be in that group.
That's correct.
Okay. Ms. Warlick or Mr. Abate, did Mr. Byrd implicate others or just Mr. Shannon? In other words, would we need to worry about this for any of the other 1 through 10 defendants, Chambliss, Clark, Maloney?
We would.
Okay.
Clark is, and my recollection is that he does also implicate Mr. Hoover's client. So it would be an issue that would affect probably all the defendants involved in the December 29th incident.
Okay, whatever the date was.
Yes.
Okay, got it. So Ms. Warlick, I think you have appropriately flagged this. I think the answer is going to be TBD because it depends who's still in the mix. But it sounds like Mr. Byrd could not be tried with your client or Mr. Hoover's client if the state was going to use the full statement of Mr. Byrd. And then we need to litigate if the state wanted to use parts of it, if those parts were admissible on their own, or if the part that gets carved out that would protect your client's rights, then leave it as a misleading or somehow meaningfully incomplete statement. Who knows at this point? But now I know that Mr. Byrd may not be able to be joined with a few of the other defendants. Okay. That is very helpful. Let's turn then to your second motion of excluding prejudicial or irrelevant evidence. Tell me what specifically you have in mind, because of course you're free to object at any point during the trial or in advance if you know, hey, the state was going to play this video, State's Exhibit 6, and 401, it's not relevant. It's a video. If, for example, we were trying only defendants who were in counts 1 through 10, and it was a video about count 19, then you might say, well, Rule 401 is not relevant. Could be prejudicial because maybe they mention your client because they're friends, but your client's not connected to those events. Was there something specific, or were you sort of flagging that this is such a big oral indictment, we need to be ready to guard against information that's not relevant to Mr. Shannon somehow coming into the trial?
So, yes, Your Honor, I did put it in just a flag and just say, hey, we've got a whole bunch of stuff here. We've got significant dump from Instagram. So all of those pictures don't necessarily have relevance to them. There are pictures in particular where my client is pictured with a gun. That there's no tie between the gun he's pictured with and then the firearms that are alleged to be used in any of the counts that he's charged with. Then we have text messages, or I should say Instagram messages, particularly one that took place after the incident, where my client makes a statement that could be characterized as mocking the victim in this instance. And I don't know what the relevance of that would be, because it doesn't show his involvement. Unfortunately, we live in a culture now where it's a disgusting practice, but people do mock the dead. They mock the death of George Floyd, Ahmaud Arbery, Trayvon Martin, even Charlie Kirk. So this is just where we are.
Fair and balanced.
This is just where we are. So I don't see the relevance in it. It doesn't mean that he was more likely to have committed or participated in that crime. So those two things in particular jump out at me as having no relevance.
Okay.
But everything else I think will just have to be addressed as it's presented.
Okay. My thought is, but I'll hear from Mr. Abadi in a moment, is that sort of like the severance motion, I'm going to defer this one because of where we are now. And I wasn't trying to get out ahead of things by having the motions hearing. I set it down partly before I had combed the docket in case it was a motion to suppress an ID or the kind of thing where you needed a ruling to be able to meaningfully advise your client, you know what, the gun with your fingerprints is coming in at trial. That's a very different case than if it's not coming in. But there are none of those motions so far from any of the lawyers. It's not that kind of case. But you needed to file by the deadline. And so what I'm going to do is defer on this one because before trial, you'd be getting an evidence list from the state, or at least a sense of, we're going to use this, we're not going to use that. And that way, in a motion in limine, you really could renew this to say, hey, I told you about these photos of my client with a gun, and I talked about them with the prosecutor, and the prosecutor's insisting that they are going to use them. And I don't want to be objecting after it accidentally pops up on a screen in front of the jury, but I want to sort this out before we start trial. And we can certainly do that. But some of the things that you're concerned about, the state may not be using, or as we get closer to trial, the state may be in a better position to articulate how it is relevant, or at least how it's probative, because your client holding a gun, I can see how that's relevant, but you'd probably be arguing 403 that is relevant, but it's not a gun connected with the crime. It just makes my client look bad. But if the state says, look, we know the defense is going to be, I've never held a gun before, I'm not a gun guy, all of a sudden it is probative. And more so, I don't think we're at a juncture now where I'd hold you to know exactly what your defense is going to be, and for the state to say, we know that of the 10,000 Instagram postings, these are the 11 that we're going to use at trial. Are you all right with that?
I am.
Okay, so you waive nothing, and we'll crystallize this as we approach the eve of trial. Mr. Abadi, anything you want to add about prejudicial or irrelevant evidence?
No, Your Honor, I have nothing to add. I think the way that you've articulated and framed it is exactly how I imagine.
Okay. I'm glad I satisfied your imagination. Last one that I found in the docket, Ms. Warlick, is that you filed a motion, you labeled it motion to quash. It was a special and general demur. And so if you could articulate what it is that you think was either insufficiently pled, such that your client could admit to it and wouldn't commit a crime, or it was insufficiently pled in that you and your client don't know exactly what you're defending against.
I think that the criminal street gang count is insufficiently pled as it pertains to counts 1 and this one particularly. So
yeah, because there are 4 counts. I just need to be real clear which ones the state needs to defend.
all right, so I'm only going to argue 1.
Count 1?
Yes.
Okay, got it.
Well, at this point, I'm count 1. It refers to that one cites the OCGA 1615-4A, and what is missing there is that A does not permit for that particular criminal street gang activity to be done alone. And although there are multiple co-defendants listed under this, there's nothing in the indictment that says that they were acting in concert. It just says it could be one of them in some way, but it does not necessarily mean that they were acting in concert. That one's not fleshed out yet.
Okay.
And so that's my position on that aspect of the criminal street gang. And I articulated that in paragraph 10 of the motion. And then I jumped down. I do have it for all of them, but just for different reasons.
Okay.
So then if I jump down to 3, 3, it doesn't contain any language that they intended to maintain or increase their status or position in the street gang. And for at least subsection B, it requires that the defendant have an intent to maintain or increase their status or position in the criminal street gang, or to be a violation of that subsection. And that's not articulated in the indictment. Now, are these the strongest arguments? No, the case law has been that if it tracks the language sufficient enough, that I'm kind of stuck.
Right.
But I've got to put it out there.
Okay, I hear you. And better safe than sorry, because if you overlooked it, then that's going to be unfortunate for Mr. Shannon down the road.
Now, my more novel argument is going to pertain to the counts related to the robbery and theft. That's in count 4. So, or 4 and 8, I apologize. So count 4 is for the criminal street gang. Actually, I'm sorry. Count 4 is the aggravated assault. So for aggravated assault.
So count 4, just so I'm following along, is the 4th of the 4 gang counts, and it's the subsection E. So it's saying that your client, among others, caused and encouraged each other to participate in gang activity. So it's the encouragement, let's go do this.
Correct. I apologize. I meant to say count 9. I'm looking at the old indictment. Count 9 is the aggravated assault. In count 9, it's articulated that
they committed an assault upon Mr. Van Arsdale by shooting him with a firearm.
Correct. Sorry, again, I'm missing this.
That's okay.
Got it. I apologize. That was count 8. Okay. Thank you, my love. I've got too many indictments. Okay. So with count 8, they are charged with the theft of the marijuana. And the problem with that one is the armed robbery count is saying that they took the property of another. Well, the only property that they're articulating is marijuana. Property requires somebody to have interest in it. You cannot have interest in a contraband. So
This is your novel argument.
this is my novel.
Got it. Okay.
There cannot be an armed robbery if I didn't take property of someone.
Okay.
And so nowhere in our statutes have we allowed anybody to consider any sort of contraband as property, because one must have an interest in it for it to be property, whether that's land or personal properties. Property has always been defined as having an interest in something. So because you can't have interest in contraband, this cannot be property, and therefore the elements of armed robbery fall off.
Okay. I haven't heard someone articulate that before, but you said it was novel. One hiccup for your argument is not the marijuana piece, but of course, count 8 says that your client and others took from Mr. Van Arsdale, not just marijuana, but an automobile. So I think part of count 8 would survive. And the question would be, is there a directed verdict or something about the marijuana piece? Or maybe it would be articulated before trial that if I agreed with your novel theory, that the marijuana piece would need to be redacted and that the armed robbery would be limited to the automobile. I don't think it would, if I agreed with you, it would extinguish count 8 in its entirety. There would just need to be, again, if I agreed with you, no discussion of the marijuana being taken. I think the marijuana is going to come up because, as I'm remembering what we've talked about in some of the bond hearings, that was the reason why people were getting together, was to have a transaction with that involved. But I'm going to have to think through the contraband piece.
I throw some case law in there in my argument.
Yeah.
Yeah, so.
Okay. Right. No, you did. It's not out of thin air. I appreciate it. It's good.
I'll submit on the rest.
Okay. On your pleading. Got it. Mr. Abadi, anything you want to share from the state side as to the motion to quash?
What I would share from the state side as it relates to generally each count of the indictment that defense counsel challenged in her motion. What I would submit to the court that in each count contained in the indictment, each one tracks the statutory language of the offense, identifies the predicate criminal act sufficiently and sufficiently apprises the defendant of all the charges in which there are the subject of this demur, specifically the gang count, Your Honor. And in her motion, she references the Rodriguez case, and what I would submit to the court is the Rodriguez case actually is a case that would support the indictment as is, because what is required by Rodriguez is just that it track the statutory language, and each one of the gang counts do exactly that. There was a challenge as it relates to, I think, counsel referenced count 3 requiring that it didn't have with the intent to increase or maintain his or her status. That wouldn't be required in count 3 because count 3 is under subsection
C.
So
Okay. Well, I'll go through the motion again. I know that Ms. Warlick touched on a number of counts, and I just wanted to give her an opportunity to expound on it here, and in particular, the contraband one, because that to me was the most novel of the arguments, and it was helpful to hear her thoughts on that.
And then as it relates to that, I believe counsel referenced the Barrett case during or in her motion. And I would submit to the court that that case actually says that it's not an interest in, it's in possessing the item, the personal possession, not the interest as described by defense counsel. So as I was looking for cases last night, I didn't come up with any cases because the Barrett case actually involves the armed robbery of cash, cell phone, and marijuana, which was found to be sufficient as it relates to that case. So if I'd like to continue my search, if the court would give me some time to supplement, and then obviously I would send it to defense counsel as it relates to that specific issue.
Okay.
But other than that, Your Honor, nothing further.
Okay, thank you. Mr. Shannon, we've just been talking about some important motions your lawyer filed on your behalf. Do you have any questions for me about anything we discussed? Do you have any questions about the terms of your bond? Remind me how old you are right now.
15.
So, Ms. Singleton, what does that mean in terms of your supervision versus it going to, I know you're connected to pretrial services, but your special pretrial services, what does that mean now that Mr. Shannon is 17? Nothing changes. But that's not for, is it 21? When would someone be out of your reach?
When the case is over, Your Honor.
Oh, once with, always with.
Yes, Your Honor.
Okay.
The courthouse is 26, the finishing section.
We will not get to 26. Okay, that's helpful to know. Mr. Shannon, you need to continue to be on point with the things that you're doing. You face real serious charges, and you had good support at the bond hearing, and I don't want to come to regret the decision that I made to connect you with the resources that we've connected you with, okay? All right. Ms. Warlick, anything else on behalf of your client?
That's it, Your Honor.
Okay, we have a tentative trial date in August. Mr. Shannon may go to trial, he may not sure. But Mr. Hoover's already blown that date up for us. Right now, do you have anything specially set in some other jurisdiction for 6 weeks? Great, try not to change that. Okay. Mr. Body, anything else on behalf of the state?
No, Your Honor.
Okay, thank you for your time on this case, everyone. We will be in touch. Mr. Hoover, who's the right person at GPDC to nudge to say, we need lawyers on this case?
Take care of that right so they can actually.
Okay, do you know who the two are?
The two, who are the two?
It's Mr. Chambliss. That's who Ms. Williams represented. And then Mr. Few. And that was Ms. Gordon from local PD's office. And she claims that she let Mr. Haddad know, and I know Mr. Haddad is usually the conduit to your office, but we do need someone to jump on. They need to get their hard drive and do all the hard work you guys have already done in wading through that discovery. So I'll hold off on sending an email, but I will probably send an email next week if we're not hearing something. Although let me check before you go. I don't want, if someone has actually filed an entry of appearance, I want to make sure. Nope, Ms. Williams is still listed for Mr. Chambliss and Ms. Gordon for Mr. Few. So if you could rattle the right cage, please. I appreciate it. Hey there. Good to see you. You are for our 10:30.
Yes.
All right.
146.
We've got Mr. Cook and Mr. Pendleton. Can you two turn on your cameras, please? Mr. Pendleton, you got all dressed up for Zoom. I appreciate that. You can be anywhere. You can stay right there. You just need to make that camera work so Ms. Rivers can see you.
Okay.
Absolutely.
Good morning.
And just off the record, Mr. Cook, I did respond to your email belatedly, but I just sent you a response.
All right, Ms. Williams, are you ready to go?
My electric brick is powering up.
All right. For future reference, we have plugs right in front of you. I don't know if you just reached down underneath, but we've got that set of sockets.
Thank you, Judge.
Sure.
Judge, can I have 1 minute? I just got an email from Ms. Williams. I just want to pass it on to Mr. Pendleton real quick.
Sure.
Thank you.
We're
Answer
firing
the
up
phone for a second, Aaron Michael.
Pardon me?
If you'll put on mute, Aaron Michael, and I'm going to call you real quick. I'm going to tell you what's going on.
Are you good?
I'm ready.
Good.
Michael is ready. I've conveyed your message to my client, and we are ready to proceed on those terms.
All right.
Thank you.
This is one of the most involved plea resolutions I've had in a long time. Let's get on the record. This is position 13 from our trial calendar, 25 SC 002 761, State versus Pendleton. Mr. Pendleton is appearing virtually. Mr. Cook, his attorney, is appearing virtually from a different location than Mr. Pendleton. And then Ms. Williams is here in court for the state. Mr. Pendleton, before we start with the plea discussion, I need to clear a couple things up with you. First, You can appear where you are, that's fine with me, but that means that you are waiving your right to be here in open court. Do you understand that? You got to unmute now and there you go. Do you understand that?
Judge.
Great.
Yes, Judge.
You also have the right to have Mr. Cook by your side. He is virtually by your side, and you can talk with him if you need to in the way you just did. But he will not be seated right next to you during the plea. Are you okay going forward that way?
Yes, Judge.
Great, then that's what we're going to do. In just a moment, Ms. Williams will put you under oath. She will then proceed to ask you questions about your rights and your case. You need to answer her questions completely and truthfully. I also need you to let me know if at any point you've got a question or you can't hear us because of the technology so that I can address that. Will you do that?
Absolutely, Judge. Thank you.
Great. Ms. Williams.
Thank you, Judge. And I would like to say at the outset that Mr. Cook has advocated for his client wonderfully. This has been very complicated, but it will become clear in a minute why it has been complicated. So,
and my observation was not a critique. It means that there was good lawyering on both sides, where this is being fine-tuned and then the fine-tuning is being fine-tuned.
Yes,
but that's the hallmark of thorough lawyering.
And that is Mr. Cook. He is extremely thorough.
Well, it takes two.
Mr. Pendleton, if you could please raise your right hand, sir. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Thank you, sir. You may lower your hand. Could you please state and spell for the record your full legal name?
Aaron Michael Pendleton, ARRON-MICHAEL-PENDLETON.
Thank you, sir. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you, sir?
24.
And what is the highest level of education that you have completed?
Third year of college.
And so you did then complete high school, obviously.
Yes.
Okay. Are you therefore able to read, write, and understand the English language?
Yes, ma'am.
Mr. Cook, on behalf of your client, do you waive formal reading of the indictment?
Yes, I do.
Mr. Pendleton, do you understand that you are currently charged with the following offenses? Use of computer service to seduce, solicit, lure, or entice a child to commit an illegal act, and criminal attempt to commit child molestation.
Yes, ma'am.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Cook, about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney right now?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Cook, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
Yes.
Mr. Pendleton, have you been arrested on these charges?
Yes, ma'am.
Mr. Cook, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
I do not.
Mr. Pendleton, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
And just for the record, the charge that we are going to recommend that the judge allow you to plead to is count 2, which would be criminal attempt to commit child molestation. Because it is a criminal attempt, it carries a sentence range of 1 year to 10 years. Do you understand?
Yes, ma'am.
Ms. Williams, does that mean that you will be seeking to dismiss count 1?
Yes, that's correct, Your Honor.
Okay. Thank you.
Sir, do you understand that if you are pleading guilty to a crime against a minor, including kidnapping, false imprisonment, or conduct of a sexual nature involving a minor, or if you are pleading guilty to a dangerous sexual offense as defined by state law, you will be required to register as a sex offender?
Yes, ma'am.
Sir, do you understand that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, ma'am.
And Your Honor, the terms of the joint recommendation are that, again, the state no pros the computer service count, and that Mr. Pendleton be allowed to plead guilty to count 2 criminal attempt for a sentence of 5 years of probation, and the special conditions on that probation would be those required by the sex offender registry.
Okay.
Mr. Pendleton, having heard the terms of the recommendation, do you wish to proceed with this plea?
Yes, ma'am.
Sir, do you understand that, and I'm not saying that you will ever receive another conviction or be involved in anything else in the future, but should you ever receive another conviction, this particular conviction could be used to enhance sentencing. Do you understand that?
Yes, ma'am.
And do you understand that that applies to any jurisdiction, including the federal courts?
Yes, ma'am.
Sir, are you currently on probation or parole?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
So do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea could affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Sir, are you intending to request that the judge provide you with first offender treatment?
Yes, please. Yes, Judge.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or no contest to or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No, ma'am.
Has Mr. Cook explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you still wish to proceed with a request for first offender treatment?
Yes, ma'am.
I'm now going to go over the individual rights that you are waiving by entering a plea of guilty. Sir, do you understand that you do have the right to plead not guilty?
Yes, ma'am.
Do you understand that if you plead not guilty, this matter would proceed to trial?
Yes, ma'am.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses, any assertions of self-defense, and any assertions of immunity from prosecution?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? Do you understand that you are giving up the right to trial by jury,
Yes, ma'am.
as well as the right to remain silent and not incriminate yourself,
Yes, ma'am.
as well as the right to confront witnesses against you,
Yes, ma'am.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
as well as the right to the presumption of innocence,
Yes, ma'am.
as well as the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
as well as the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
as well as the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that you are also giving up the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 25SC002761, how do you plead to count 2 criminal attempt to commit child molestation?
Guilty.
Is the guilty plea that you have just entered given freely and voluntarily with full knowledge of the charges against you?
Yes, ma'am.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35, and Mr. Cook can provide you with more information about that. Do you understand?
Yes, ma'am.
You also have certain habeas rights, which Mr. Cook can also explain to you, but those expire in 4 years for a felony conviction. Do you understand that the appeal and documents that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes, ma'am.
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
Mr. Pendleton, that concludes all of the questions and information that I have for you. Your Honor, as to a factual basis for this plea, the arrest in the matter is the product of an undercover operation by Alpharetta Police on December 10th, 2023. Mr. Pendleton, who was 22 at the time, and undercover members of Alpharetta Police engage in discussion on a site like FetLife or something similar. Early in the exchange, the undercover officer gives to Mr. Pendleton a cell phone number for communication via text messaging. The undercover officer informs Mr. Pendleton that she is a mom attempting to get her 12-year-old daughter, quote, experience with a man. Defendant asks for a picture and is sent one with faces covered, showing 2 females, with one the approximate size of a 12-year-old as compared to the taller female. Defendant asks the mom if mom wants penetrative or non-penetrative experiences for her daughter. Defendant asks mom if she wants to be involved or demonstrate, and mom says that she will not be involved but will be in the next room. Defendant agrees to bring lube, condoms, and weed. He states that, quote, "This is a thrill, to be honest," end quote. Defendant drives to the meetup point that the undercover officer posing as mom set up, which is the pool house of the community in Alpharetta, which is within the bounds of Fulton County. The undercover officer posing as mom informed defendant that from the pool house, they will then walk to the house where the 12-year-old daughter is waiting. Defendant is arrested after confirming that he is at the pool house via text message. Mr. Pendleton then speaks with investigators after being Mirandized. He states that he was curious as to whether there were real people behind the account. He stated that he never intended to have sex with a minor, but that he was intending to try to talk the mom into having sex with him. He states that he did not bring lube, but had condoms because he always keeps them in the car. And because of the negotiations between the state and defense counsel, we arrived at this recommendation. So, Your Honor, we would just ask that at this time you accept the plea as negotiated.
Okay, I got a couple questions.
Yes, Judge.
Give me 1 second to be. First has to do with first offender. My read of first offender is that I cannot sentence, I don't think I was going to anyway, but I don't think I can sentence Mr. Pendleton as a first offender. And I'll let Mr. Cook air it out as well, but I expect this is one of the many things you guys went back and forth on. And just to march us through it, 42-860 sub J says the court shall not sentence as a first offender if, and it lists a whole bunch of things like serious violent felonies. That's not this, but it does include J2, a sexual offense, as that term is defined. Of course, we have to go elsewhere. 1710 6.2. If we go there, child molestation is listed as a sexual offense. So that says, at least on the surface, child molestation is not a first offender-able offense. With one exception, but that's when it's I'm a 16 and my girlfriend is 14. Not this case. Doesn't say anything about attempt. And so that may be where there's the gray area. And so I'm interested first in the state's perspective. In due course, I'll hear from Mr. Cook on that.
And Your Honor, I did review the same statutes that you just referenced. I did as well review some case law and explained my position and my understanding to Mr. Cook. He stated that he had some arguments that he would like to present to Your Honor. And at this point, as part of the joint recommendation, I am willing to allow Mr. Cook to make his arguments, and should Your Honor accept those arguments, the state would not oppose.
Okay, appreciate that. Second question, the more difficult one. It's not based on law. It's just I'm trying to separate my experience in my former role as a federal prosecutor from your role as a state prosecutor. Had the undercover been an FBI agent and this played out the way it did, Mr. Pendleton would be facing at least 10 years in prison. At least, that's the mandatory minimum. Different laws, different setups, same conduct. This is someone who not just engaged in the chatter, but took the substantial step of driving to the pool house. And he can say, I was curious and really I was going to go for the mom and not the kid. But I'd like to hear from your perspective as the prosecutor and handling a range of these cases at the state level, how a sentence of probation resonates with you. And I'll compare it to cases that your colleagues have where it's just images. And I recently handled 2 of those. And there was someone who appeared to be sort of an incidental collector of CSAM, as in he was browsing, and because you sort of swoop up everything he had, it was like 10 images. That's not good, but that was it. The other defendant was clearly, he hid it and it was categorized, and he's going to prison. That was the recommendation from your colleague. That was, and I'm putting in air quotes, just images. Still a terrible thing. He's trafficking. He was also making it available to others, re-victimizing the kids in those images. In my thinking, the next tier up would be producing those images. The next tier up would be, I'm going to go be with the 12-year-old. And that's what Mr. Pendleton, by your account, was trying to do. What have you learned from Mr. Cook and these evaluations and whatnot that makes you comfortable that Mr. Pendleton should remain in circulation? And we shouldn't worry about other 12-year-olds in Alpharetta or anywhere else.
So from the evaluation, Mr. Pendleton did receive a risk assessment of low to below average. Additionally, a lot of this recommendation is based on the advocacy of Mr. Cook. He's provided me with information about Mr. Pendleton and his life, about things that were going on in his life at the time. And that's the largest reason that this recommendation is going forward. And additionally, because Mr. Cook came to me early to talk about this. So that's how long it's taken to work this out. Beyond that, I think that I've made my position clear to Mr. Cook. He's made his position clear to me. I completely understand and agree with what you're saying. However, this defendant is extremely young, and he is young. He was extremely young at the time, and this is the recommendation that we were able to reach through negotiation.
Okay. Do you have are there evidentiary concerns you have? Because sometimes a prosecutor will come in and look at the allegations and say, I'm here, and my hand is up higher as a higher sentence. And then reality sets in of, the lead detective's been fired because he stole from the office, or this is going to be suppressed by the judge, and you lower your expectations because we're never going to find our victim, or there becomes an evidentiary issue with the case. This doesn't sound like that kind of case, and I didn't hear you. Sometimes, wisely, a prosecutor will kind of obliquely reference, like, without wanting to reveal, like, well, there were some complications with our case. But here we don't have, that 12-year-old is homeless and she can be hard to find. There was no 12-year-old. It was a detective who, my guess is, raring to come to court if needed. Were there evidentiary concerns you had about the case that led you to where this ended up?
No, Judge. And additionally, I would like to say that Mr. Pendleton literally has nothing else on his criminal history, not DUI, not anything.
Okay.
So that also was part of the consideration.
Got it. Those all make sense. I appreciate you sharing that. Let me hear from Ms. Harvey. Ms. Williams may have just stolen your thunder, but criminal history for Mr. Pendleton.
He has no criminal history, Your Honor.
All right. Thank you so much. Appreciate it. We will not be handling criminal matters again till 1. You're welcome to stay on. It will be this Zoom, but you're also welcome to drop off and live your normal life. But if you could be back at 1, that would be great.
I will. Thank you.
Thank you. Mr. Cook, I don't mean to sound ominous, but it's important you hear my concerns because I don't know how this one's going to sort out. So why don't you share with me how you got the state to 5 years probation?
Judge, thank you. So Mr. Pendleton was a 22-year-old Morehouse student at the time. He was critically, he was in a relationship with an older woman at the time, nearly twice his age. In Lithonia, they were living together, and they had a fairly in discussions with her, and she'd be available as a witness if, as needed. They're no longer in a relationship, but they had I guess she described it as a sort of fetish kind of relationship. And so they had a sort of explorative sexual relationship. And he was on a website for adults, approached by a woman, posed as an adult, and only in that conversation did it turn into the police adjusting it to something else. And so again, it wasn't like he was responding to an ad for a child or a mother looking for an experience. He was responding to an ad or a classified or a post of another adult. And so it's a bait and switch. And that's my argument. And I understand that they're allowed to do the bait and switch, but it's a factor in my opinion as to what the inclination is to the individual, what they were out looking for versus what they sort of got hooked into. And so it doesn't necessarily, I mean, it does still create a problem because, he didn't stop. That's true. And that's why we're here. We did have him evaluated. He is low risk with no criminal history. He doesn't have any children. He doesn't live with any children. He lives with his mother in Las Vegas. Moved back there after basically saying he broke up with his girlfriend, left Morehouse. He's a bodybuilder by that's his career now. And he was in nursing, and that is gone. I mean, that's the first thing that has just been obliterated. His nursing career that he was in school for at Morehouse is gone. And he knows that. And that was the first tragedy, spending a couple months in the Fulton County Jail and this. But Judge, he has behaved admirably for the last couple of years, with no issues. He was on pretrial for a little while until they released him. Judge, given his age, I'll say this: your questions as to the big distinction between the federal prosecution of these same cases versus the state prosecution of these cases. It's a real one, and we see the same thing happen with felons in possession of firearms, where the exact same offense just depends on who decides to pick the case up, can result in a drastically different offense. And why that it's beyond me. It's even beyond your decision making when you were a federal prosecutor. It's kind of we pick the cases that we get, and the sentencing range in this state does authorize straight probation, even for the count that is being null prosecuted. It's a 1 to 20, and so I think if they wanted to prosecute in federal court, they could have, but here we are, and I think it's a result based on all these factors that I've just talked about. And then I want to bring up the question about the first offender. The first offender thing is really interesting. I did some research on this. There is no case on point. However, the charge in count 2 is not child molestation. It's criminal attempt. And criminal attempt is not included in either the first offender restricted or in the 17-10-6.2 sexual offenses. And why we know that it is not included is because they could have put the word in there, attempt of any of these crimes. And we know that they can do that because in the sexual registry portion, they do have a catch-all that says attempt of any of these offenses, attempt of a crime against a child, attempt against or any crime of violence. And I'll say that yesterday in court, it was a noticeable one. For instance, there was a case yesterday, we had ag sex battery reduced to aggravated assault with intent to rape. Aggravated assault with intent to rape is a registrable offense, but it's not included as a sexual offense, and it's first offender eligible. A criminal attempt is just not excluded from those. He's still going to have to register. He still has to register. And this is, I believe that first offender should be a motivator, and it should be a carrot as well as a stick to turn a 5-year sentence into a 10-year sentence if there's a violation, if it's under first offender, and to incentivize someone to complete their probation without any problems. I believe with his low sexual evaluation, it is highly likely that he'd be a good candidate for removal from the registry subsequently anyways. And so this is that in consideration, given the fact that he is a true first offender. And so those are the reasons that we made this proposal. I find these very hard because Mr. Pendleton I don't know, it just wasn't, he was just a regular college kid and caught up and made a mistake, and he's going to pay for it. And the rest of the next couple of years is going to be very challenging for him. And so for all those reasons, we'd also ask the court to consider, we would consent to a banishment. I mean, he's in Las Vegas now. He does not have to come back. We would consent to that. Sometimes I fight banishments, but this one, as long as it's a recommended one, I have no problem with a banishment, and him not to return. But I think that's my position, Judge.
Got it. Okay. Can't tell from looking at the prior hearings in this case if Mr. Pendleton's final plea rights were preserved. I'm not going to go along with 5 years probation, but before we go beyond that, I wanted to suss out what people remembered about whether, and this may not have been your case throughout, Ms. Williams, because of the transitions in your unit. It's been Mr. Cook's throughout. And in looking at when we had hearings, the final plea hearing was back in November, and there's not a notation that I have, but I'm going to ask Ms. Nelson to check to see if Mr. Pendleton back in November rejected the state's offer, or just because I'm remembering there was so much healthy back and forth that I likely preserved his final plea rights so that Mr. Cook could do the work that he had to do on behalf of his client. Is that your recollection, Ms. Williams?
So, Your Honor, Ms. McGillicuddy did appear on this case, and I have an email that I sent to her on January the 5th, 2026, where I did state to her that, quote, judge preserved defendant's final plea rights.
And that is my recollection too, Judge, because we actually got our first offer yesterday. I mean, that was part of the issue, is we'd never actually received any kind of offer until yesterday.
When you say your first offer, had you been advocating for something and what you didn't get till yesterday was a response to your advocacy?
I have done multiple things. I have been early on asking for basically any offer to get a starting point so that my client would know what we're dealing with, what the realm of possibilities are. And then I was invited by both Ms. McGillicuddy and Ms. Williams to make proposals. I mean, I made some tall orders, and I understand that, but I still made several proposals that were anyway, and finally the first response back was yesterday.
Okay, got it. So I'm going to assume the final plea rights were still in place, which means you'll be able to back out of where you are right now. Because if we went forward with the plea today, we couldn't, because Mr. Pendleton is not here. He's in Las Vegas, which is a little confusing to me because the system lists him as a Lithonia address. So one thing that needs to happen today is that a change of address needs to get filed. I don't know what the conditions of bond are, but I also don't know that being in another state is consistent with whatever the bond conditions are. I'm not saying there was anything purposeful. I've got this Lithuania address and not I'm in a whole nother state address. So we need to clear that up. I'm going to put it this way. Banishment doesn't address my concerns because there are 12-year-old girls in Las Vegas. And you referred to Mr. Pendleton as an ordinary college student, but an ordinary college student doesn't arrange with the mother of a 12-year-old to rape the 12-year-old, because sex with a 12-year-old when you're 22 is rape. That's the law, and appropriately so, because a 12-year-old can't consent to that. And I appreciate what it was relayed that, I was just curious and I was really hoping that I'd score with the mom. But we are not in a space where a 5-year probated sentence is going to work based on the facts as I heard them. Maybe that means this needs to be a trial. And when a jury hears the facts and I hear them, it turns out that it was something different, and it was someone who was curious about legal, consensual sex. That's not what this sounds like. And that's a problem. I appreciate the evaluation that was done. I appreciate that there's no criminal history. That doesn't mean something like this didn't happen before, no one was caught. But more fundamentally, it doesn't mean that this didn't happen. And so the first time someone robs a bank, hey, it's the only time I've robbed a bank. You still stuck a gun in the teller's face and said, give me all the money. We don't say it's a less serious bank robbery because it's your first. This is not a less serious I made concrete arrangements to have sex with a 12-year-old. And that doesn't go away through any set of machinations and evaluations and whatnot. And so this is not a probation case for me. Whether that means you want to still work it out by way of a plea, you can do that. But it may be that, given what you're hearing from me, that you want to go to trial because you think that a jury will hear it and say not guilty, that the state mischarged it or overcharged it, or the evidence isn't there. The state's null pros of count one only would apply if this was a plea. So if it's a trial, it's both counts. But I cannot in good conscience sentence Mr. Pendleton to probation only, given what I've heard. So unfortunately, you'll need to unwind where you got. I do need to ask if the state could be ready on week 2 of this trial calendar. I won't say, hey, I'll see you guys on Monday. That's not fair. And then I'll turn to Mr. Cook. He may have scheduling issues, and I recognize his client is all the way in Nevada. Again, not sure when that address change occurred.
You'll see that it is one of the mistakes is that although his thing is still listed as Lithonia, you'll see that as the surety, the mom, I think that was where it does say right below it, the Nevada, that's where mom was. I think there was a mistake that we didn't change his address because I saw that I thought it was changed, but I think I'm looking at mom's address. That's because that's where he is. So
okay.
I'll get that changed.
Great.
But it was only after pretrial, he was finished with pretrial.
Got it. Okay.
We're done.
Understood. So Ms. Williams, turn into you first. The trial calendar has contracted a whole lot and there aren't many cases left. We're going to tackle our speedy demand on Monday, and then there are a couple others, but one of them is older. I mean, one of them is less old than Mr. Pendleton's. Is this something that you could put up our second week? Or do you need to check with witnesses because you were not gearing up to try this case?
I do need to check with witnesses. I'm sure, as you know, Your Honor, all of the witnesses would be, the majority of the witnesses would be law enforcement professionals. At the court's pleasure, if that's Your Honor's request, then we would be ready for week 2.
I don't want to, if neither side was viewing this as trial and getting ready in that way, but that week is available. That will likely be available, meaning the whatever 2 Mondays from now is.
So, okay, so no, I was not preparing it for a trial, like doing 2 tracks at one time. No, Your Honor, I was not doing that.
Okay. Mr. Cook, what is your calendar for the week of the 23rd?
I have a few trials going out, jury trials with Judge Krause. I know that. And look, I'm looking back. Let's see here.
Well, why don't we do this? Because it sounds like both sides, the mindset very much was, hey, we've worked it out. And you may still work it out. I'm going to have Ms. Nelson put Mr. Pendleton on our next trial calendar, which is the April calendar. It wasn't, I don't think it was on there because we thought it was going to be resolved here. And I'll prioritize it. I don't mean for Mr. Pendleton to travel from Nevada if he doesn't need to. But that will also give the two of you a chance to regroup, because it may be that, as unhappy as Mr. Pendleton may be with how today went, it's still not a case he wants to try. And then there could be maybe a non-negotiated, state recommends this, or you guys may come back and say, we still recommend 5 years probation, but you'll be going in eyes wide open that that's not where I come down with this. And then it would just be, well, let's see what we can convince the judge to do. But that'll give you time to have those conversations. That's not meant to be time like, I'll get him another evaluation. That's going to take 4 months. That's happened. And it's helpful to know what an outside professional had to say. That is not without merit, and that is something that would influence where I come out on this, whether it's a guilty verdict or it's a guilty plea. But it still doesn't get me to the place where I'm comfortable with a sentence of straight probation. But I've told you all what I think. We'll move it to the April calendar. Any questions about any of that, Ms. Williams?
I believe that, I have notes here that the April trial calendar would be April 27th and then the second and third weeks of May. Was that?
Correct.
Okay.
Well, so the April trial calendar is just that week of April 27th.
I see.
And then we will be calling another calendar on May 7th.
I see.
And then that captures those next 2 weeks. And I'm viewing the 3 weeks as interconnected. So just as an example, if Mr. Cook had a conflict the week of April 27th, then hey, let's look at those 2 weeks in May and maybe we could do the case then. So it just happens to be two different calendars. Otherwise, it would have been like a 60 position calendar and it's not fair to anyone. So I am looking to have this added to the April calendar, which would specifically with that calendar, put you all in the queue, high up in the queue, for the week of April 27th.
Understood,
Okay.
Judge.
All right. Mr. Cook, any questions about that or anything about procedure?
I guess I would be remiss to say if the court sentenced Mr. Pendleton today, does the court have a, is the court able to tell us what the court is thinking so I can prepare my client and we can have a meaningful discussion for plea versus trial?
I'm not comfortable saying that because neither side was in a position to be articulate about their thoughts with a custodial sentence. But I also recognize the range is 1 to 10 if it was still a plea to count 2. And I think it would be very important for the sentence to also have a meaningful probated term. That's about as much guidance as I can give you.
Thank you, Judge. That's very helpful.
You bet. Okay. Mr. Pendleton, it is important that you continue to do what you've been doing, which is stay in touch with your lawyer and stay out of trouble. He is going to continue to advocate for you and is going to give you some good guidance about what's next. But you should not take from what I said as a reason to disappear. Okay? All right. We'll get this on the April calendar, and then if for some reason you all sort something out and want to come in, let's take the plea before the calendar. But otherwise, know that you'll be on it, and even though it's a big crowded calendar, there are a whole lot of cases on there that are theft and this and that I don't envision things that will go to trial.
Understood,
Okay?
Judge.
I appreciate everyone's time on this. I know you put a lot of energy into getting where you got. It just didn't get me there as well. I don't normally do this. I haven't had many cases with Ms. Williams yet, and Mr. Cook, we haven't had many. I don't normally stir the pot like this. I need to do what I think is appropriate given what I've heard, and that's where I came down. So, Mr. Cook, the one due out you have today is to get a change of address filed so that the system has the right address for Mr. Pendleton so that our notices are going to the Las Vegas address.
Yes, Judge.
All right. Thank you, everyone.
Thank
Have a
you,
good weekend,
Judge.
Judge.
You bet. Ms. Rivers, thank you for your time. And Ms. Simpson, I will see the two of you at 1 o'clock, please. We have a plea in Mr. Hardison's case.
Okay, Judge, I'll be back at 1.
Sounds
Yes,
good.
Judge.
And we are going to pivot now to part 2 of our bus repair property dispute. I am going to be back in about 2 minutes while you guys take your tables. Ms. Williams, thank you for being here.
Thank you so much, Judge.
Good morning, council. Yeah, I'm gonna kind of reduce it. Guess what happens is they rub up against stuff that's been seen.
Makes sense to me.
Yeah.
Have a floor.
I'm gonna use the restroom and go to this back.
Okay.
And this is so minor that I don't even think anybody cares, but I do. Last time I asked you if you wanted the original and you declined, and Mr. McMaster ordered the original. I'm not sure how it works on a day two, if he gets first dibs on original, I don't, so, like I said, I don't know if anybody cares, but when I take orders, I was just gonna kind of alley-oop it and say, who wants the original? If everybody orders it all.
We will see how today goes.
Yeah, that's,
But if the position is that Mr. McMaster will be counsel for the likely appellant, we will likely defer to him ordering.
okay. I've never been.
No need for Mr. Dunn to incur that cost.
Yeah, I've never had this scenario pop up, so I don't,
Well, I just, in the 2-day thing, correct.
yeah.
I didn't feel the need to
Cause normally I just,
pay for the expedited.
yeah, I always defer to who ordered me, but since you declined, I don't know. I don't know the,
Defer on what do you mean? Like, and who gets to order it?
yeah, like when I ask, who, Mr. Dave, you wanna go ahead and order the original? And you say no, and then he gets the original. Now it's kinda like his thing, cause he got the original.
Oh.
Yeah, that's what
I
I'm
mean-
saying, it's so minor that no one cares.
I will be
But
able to get it.
I
I will be
have
able
to
to get,
care.
I will be able to get a certified copy, so I will be okay.
Okay, perfect.
We have our exhibit.
And were you the only witness today?
Our tracker.
Yeah.
I didn't know for the tracker, but I remember oh. Right. And then I have the admitted exhibits.
Okay, great.
Which are these? These are the ones that are on the stand.
Okay, great. And you got all the exhibits that I sent you, correct?
Yeah, they're in the file for the first one.
Very good.
Is this thing on?
Yeah, you're good.
Okay. You can hear, I was just making sure.
Yeah. You're good. Mr. Counsel, are you the only witness today?
From our side, I believe Mr. McMaster may have a witness.
Okay.
Because we're finishing up the counterclaim trial.
I was trying to call you Mr. Dave. I don't know why. I
Okay,
guess
Mr. Ryan.
Ryan
We're
Dave,
good.
the coach.
Ryan Day is a coach for the.
Yeah,
Okay.
it's just in my.
Boo.
mind.
Indeed, boo. Although don't say that too loud, that's table, the other side. I'll start the same.
My house are Michigan fans, actually.
Okay, yeah. I'm just ribbing it.
Mr. Master, are you calling any witnesses today?
Yes, Emmanuel Smith.
Anybody else?
No.
And it sounds like we'll have 2 hours.
Can I switch your mics?
For breakfast, I'm not saying.
That was my reason.
Thank you.
Can you put this on? I swear it's more, that's what it is.
Yeah, I'm just.
Check. Check. Mic check.
Mic check.
Mic check.
Mic check.
Mic check.
All right, well, you all can be seated. Now the little microphones are back. All right, 24 CV 007261. We are back together again in VBT versus Dunn. My recollection when we were together on March 3rd, so 10 days ago, is that we got through all of this defendant's case, its counterclaim. You were sort of functioning as plaintiff, but as the advocate for the tortious interference and attorney's fees, et cetera. I think you had rested. Maybe you hadn't.
That is correct, Your Honor.
You had rested. And so we were maybe going to start with Mr. Smith, but then we had 20 minutes and Mr. McMaster, you weren't sure if you'd get through it or not, and why break it into two pieces anyway? So I think we've got the defense case from plaintiff as to defendant's counterclaims. We had left open some legal argument about whether Mr. Smith or VBT was really a stranger to the contractual relationship, since it was the tenant on the land and obviously was a party to the original lease between Mr. Dunn and VBT. So I'm sure we'll hear more about that. But that's where I'm remembering we left off. I'll start with you, Mr. Ryan. Anything more we needed to cover before Mr. McMaster calls his client?
I believe that is an accurate recipe.
All right, we're off to a good start. Mr. McMaster, good morning.
Good morning, Howard.
What's the little poofy thing?
To prevent stuff rub up against it, the sound.
Okay, I thought that I wasn't going to call him out on it, but I thought Mr. Ryan had some kind of sketchy flower on his lapel. And then I noticed Mr. McMaster, and I saw Mr. Smith had one. Like, I guess it's technically necessary.
This is the memo, Your Honor.
Yeah, I want a oversized cotton ball too. Nope, no, thank you. Mr. McMaster, anything else procedurally we need to talk about?
At this time, we're in order procedurally, so.
Great. Then let's have Mr. Smith come on up, please.
Raise your right hand. Swear affirm that testimony you'll give the truth, the whole truth, and nothing but the truth that God. Go ahead. Can you state spell your name correct?
Emmanuel Smith.
Step.
Emmanuel Smith, Smith.
Okay, Mr. Smith, just gonna ask you some questions. Opposing counsel will have questions, and I expect the judge will also have questions. Kind of picking up where we left off. Well, first of all, I represent VBT LLC, as you know. What is your relationship to VBT LLC?
I'm the owner.
You're the owner. Do you operate the business as well?
I do.
How many members are in the business?
Just myself.
Okay. as you know, this issue, or excuse me, a lease between you and Mr. Dunn, or excuse me, VBT and Mr. Dunn came up last time we were here on March 3rd. And I want to talk to you, jogging back to March of 2022. Explain to the court your view of the option to purchase the property.
Objection as to relevance.
What is the relevance of Mr. Smith's interpretation or perspective on the option?
It's relevant because they're trying to prove malice. And I'm trying to show this is a businessman trying to operate in accordance to a contract that he has. And it's not pure malice, it's him behaving consistent with his interpretation of his lease of the property.
So I'm looking back at my notes, the elements of the tortious interference is the unprivileged wrongful conduct, purposeful action with malice. So there's the malice. And you are trying to highlight that there may have been some what's perceived as interference, but it wasn't malicious.
Yes, Your Honor.
Okay.
And in addition to that, it does touch on privilege. His privilege are the rights under this lease agreement.
Okay, I'll let you explore it a little bit. What I want to guard against, and why I wasn't surprised Mr. Ryan popped up, is we've already litigated whether there was an option to purchase and all that. And that's been resolved. And so as long as you're not through Mr. Smith relitigating that, not that you then argue, hey, you need to change your mind, but we've already covered that. Not through you. This was pre Mr. McMaster.
I'm aware of that.
Okay.
And to be honest, Your Honor, the previous decisions were probably based on affidavits. I hope my client's not going to say anything inconsistent with what this court has already ruled on.
Okay.
I'm just, I guess, for background more than anything.
Okay.
Okay. Mr. Smith, explain to the court your view of the option to purchase.
At what point?
In March of 2022.
In March of 2022, I believe that my option had expired.
Okay.
That was my thought.
Okay. And you spoke to, did you speak to Mr. Dunn about your perception of your option?
I did, and I asked to arrange a meeting at Houston's to discuss extending the option.
Okay, so let's go ahead and move on to November of 2023. Okay, so we heard a lot of testimony regarding November of 2023 at the last hearing. In November 2023, did you have an attorney?
Yes, I did.
Did you have an attorney at the time of the testified conflict that we heard from TJ and Mr. Dunn at the last hearing?
Yes.
Okay. And what did why did you seek an attorney?
I sought an attorney because I thought that Mr. Dunn, because of him telling me he was going to extend my option, that now that somebody else is coming in the picture, I needed to seek counsel, and that's what started me seeking counsel.
Okay.
If you believed, Mr. Smith, that in March of 22, the option had expired, what was a lawyer going to be able to do to to change that?
Well, so what happened, Your Honor, in November, it was probably the end of November. The first thing that Mr. Ward said to me was send me your lease. And
Mr. Ward being,
previous counsel.
okay,
And so the first thing he said was send me your lease. And when he asked me to send the lease, I read it really for the first time with intent. And I said to, he asked me all of the background of what happened. I explained it to him. And I said, in actuality, my option starts on March 1st, not it ends.
March 1st of what year?
Of 2022.
Oh, that's what you figured out when you read it? Or that's what, I'm not trying to get you to disclose what your lawyers told you. You figured that out or you learned that from talking with your lawyer?
No, I figured it out. I actually told him that, and I told him everything. And then he said, well, based off of all the other information, this may be the best strategic thing is to use the extended option, whatever that was. I'm not a legal scholar, but
okay.
I just told him everything, and then
based on what you told him and what he read, he made the decisions he did.
He did, and then
okay.
I sent him the deposit in format with the option requirement.
Okay.
Mr. Smith, when did Mr. Dunn notify you that he was selling the property to someone else?
He sent me an email on, I believe it was Friday, November 17th.
And had you hired Mr. Ward yet?
I did not.
Okay, so you had no attorney at that time?
I did not.
When was the first time you saw someone come to the property related to the sale of the property?
The first time, well, on camera, I saw TJ. He came to the property on the 9th, I think it was the 19th, 2 days later on a Sunday, but formally it was the first time, I believe it was the week of Thanksgiving on, I believe it was a Tuesday.
Okay, and you were there at the time on the property?
I was.
Okay. And what happened when TJ arrived?
The three of them, it was him and two other people, and they came into the office, well, into our garage area. So there's the garage area, and he came inside there, and they had tape measures and notepads in their hand. And I didn't know they were coming, but because the week before they were supposed to come and they never showed up. And I sent Mr. Dunn a text saying that no one ever showed up. But when they came in, I assumed who they were. And I said, let's talk outside.
Okay, so prior to them showing up, at some point, Mr. Dunn did tell you someone would be coming to the property?
For the last time, yes, he did when they didn't show up. I didn't know they were coming that time at that day.
And what did they tell you? Explain to the court your interaction with them.
They said, I'm here, to do an inspection of the property. And then when they said that, they wanted to, I guess, take measurements and go through the facility. And I asked them, I said, this is not the best time. I have staff here. I have my manager here. If they see this, this could disrupt my business, because then now they may think, oh, is he going out of business? Is he selling property? I think it would create too many red flags. And what I didn't want to do was run myself out of business with this before we could get this resolved.
Did you discuss with TJ or anyone from HREP your perspective of any option to purchase that you may have?
Yeah, I told him, I said, you know, this is a shock to me because all the while I'm thinking and believing that I'm the one that's going to buy it. So, and I believe that I had that right. So this is a shock to me. And that was really, the conversation was minimal, as far as outside.
This day they came, you're saying unannounced, not in the sense that you didn't know they'd ever be coming, but the specific date and time when they showed up to take measurements and you said, this isn't a great time, I got team around. Is that when you told them? I'm also surprised that Dunn told you could buy this because I've got an option to buy it. That's when you had that interaction?
In fact, before you left.
He being TJ?
Yes, before you left, I asked him, I said, so what do you know, what's your plans? And then he was like, well, I'll let you know what I'm gonna do after we get, I guess, inspectors and other people involved. I'll let you know in about 3 days afterwards.
Did you ever make any threats to TJ?
No.
At the previous hearing, we saw TJ testify that you visited his office or the HREP office. Do you recall ever visiting the HREP office? Or prior to going to the office, did you ever try calling them?
Yes, I reached out to him. I called him about 3 times and he didn't answer.
And was that the same day you went to the office or days leading up to the office?
Excuse me. Can you repeat the question?
You said you tried calling before you went to the office. Was it the same day you went to the office?
Same day.
Okay, so you called TJ three times before going to the office.
Correct.
Okay. Why did you go to the office?
Well, on his meeting when they came out that Tuesday, what we ended with was he would let me know in 3 days after they did the inspection with the contractors. So they all came out that Saturday, which I believe was the 9th, and they did their inspection at the property.
And that was the 9th of December?
Yes, sir.
Keep going.
Oh, and so that was the 9th, and then the 13th was 3 or 4 days later. So it was important for me to understand what his plans moving forward. And I was on my way home and I said, okay, I'll stop by the office and see if I can catch him there to speak with him.
Okay, what happened when you got to the office?
I opened the door. I didn't see anyone. It's kind of like a reception area. I said hello. I didn't hear a response. And then there's some chairs there on the side. And I said, okay, I'll sit down here and wait for someone to come out.
And how long did you wait?
Maybe about 5 or 10 minutes.
And then what did you do?
A gentleman came out, Mr. Bush, and he was walking towards the door. And And then I said, he did look a little startled because I guess he caught me out of the corner of his eye because where their hallway is, or the hallway to like the cubicles feed off on the side. So when he came down and I guess got into the open area, he saw me. And then I just stood up and I said, is Timothy here? And then he said, no. And then I said, well, can you tell him that Emmanuel stopped by? And he said, what is this in reference to? And I said, he'll know. And then I walked out.
Okay, and Timothy is TJ?
Yes, sir.
And that was on what date?
I believe that was on the 13th.
Of December?
Yes.
Okay. Did they ever come by for an actual inspection?
They did on the 9th, that Saturday.
The 9th of December?
Yes, sir.
Okay, tell us about their visit for an inspection. What happened?
I had been in contact with Chase, I think his name is Westfall. He was the point of contact when they came on the 27th, that I was coordinating a Saturday that would work where they can get all the contractors out. And I had 2 2-hour windows. I told them either 7 to 9 or 5 to 7. That's Saturday soccer day with the kids. But that's
Saturday's what?
Soccer day with the kids.
Got
So
it.
I gave them 2 windows because initially they said an hour. Then Mr. Dunn said it would be 2 hours. So those were the 2 times that options that I gave them.
Okay, and all this time, you were represented by counsel, correct?
At which time? At that time?
December 9th?
Yes.
Okay.
Do you know if Mr. Dunn knew that you had a lawyer by this time, December of 2022?
He did.
And you say that because?
On December 6th, my attorney sent him an email stating that I'm exercising my purchase option and sent it, I believe, via mail.
Okay.
Mr. Dunn, you just testified that you believe your attorney gave an email. Excuse me, Mr. Smith, you testified that your attorney gave an email to Mr. Dunn. I'm going to have you look at a document, and I want you to explain to the court what this document is.
You showed it. I was not looking at what you were doing. Did Mr. Ryan get a chance to see that?
It's my exhibit 4 that I emailed.
Got it. So he has it.
You guys have it. It's, so I'm gonna go ahead and tender this document to the witness and let him testify to the court. Mr. Smith, do you recognize that document?
Do?
Explain to the court what that document is.
I believe it's just explaining or sending a message to Mr. Dunn that that law firm is in possession of the $25,000 deposit, and that I'm wishing to exercise my option.
When was the first time you saw that document?
It would have been somewhere right around the time it was sent.
Mr. Ryan?
I'm going to object to relevance to any further line of questioning. I think to establish a timeline, this is fine, but we're kind of veering into validity of the purchase option, depending on where this goes.
I'm trying to track down, but I need to look in a different location, your exhibits. So let me see if I can pull them up. Then
May I
will-
respond to his objection?
You can once I have exhibit 4 in front of me.
That's great. Let me see if I can find a copy of it.
Well, I may have them all. No, let's go here.
And once you have that pulled up, I'll have another section, Your Honor.
Uh-oh, I didn't mean for it to mount. Let's see. Step attorney. So I've got a letter, not an email. May have been emailed, but this is a letter dated December 6th from Schulten, Ward, Turner, and Weiss.
Yes, Your Honor.
Okay, I've got it in front of me. So why don't you get all your objections out, and then I'll give Mr. McMaster a chance to respond.
Certainly. Also, hearsay to the extent that we're veering into questions that ask Mr. Smith to describe the contents of the document.
Okay. Relevance and hearsay.
It's relevant because it's really just piggybacking off of your question to him where he said, my attorney told me so in an email, and I'm giving you the letter that his attorney used to tell him so.
Okay. And my recollection of Mr. Smith's answer was, I think he mailed him a letter too. So this would be, it could have been emailed and mailed.
It was both.
It was both. Okay. So this is what was sent.
Correct. Your
Okay.
Honor. And
Are you going to drill deep into what it says? Because what it says would be statements of Mr. Ward.
I'm not offering it for the truth of the matter asserted. I'm offering it as notice to my client so the court can understand my client's mindset, still attacking that malice issue.
Okay. So he's now thinking my lawyers have engaged with Mr. Dunn. Let him know my position on this.
Yes, Your Honor.
Okay.
And I apologize. I think I only gave my client one page of the letter. I have the full document here. So if you don't mind, I'd like to hand him the full document.
I would like you to give him the full document because if I'm going to admit it, I don't know if you've tendered it yet. I think there were objections to.
Questions, not the exhibit.
Right.
Not there.
Okay. So yes, he should have the whole thing.
Mr. Smith, I'm handing you the full document there. And I've labeled it Plaintiff's Exhibit 3. Mr. Smith, is that a true and correct copy of the letter you just described to the court?
Yes, it is.
Okay. I'd like to move to admit Plaintiff's Exhibit 3.
So I've got it as plaintiff's 4.
Oh, let me write 4 on there.
If it's the same, I mean, you also have an.
I'm sorry, Your Honor.
It's labeled 4, but this is the third exhibit that he is tendering at the hearing, Your Honor.
Correct.
Okay. We should call it 4 because in the electronic things you sent around, it's number 4. And so just as if I'm working on an order, I might be pulling from what you all shared and it's exhibit 4 in there. So let's call this exhibit 4.
I'm okay with that, Your Honor.
I am too.
Reflecting on that, the previous hearing, we didn't handle it that way.
Oh.
We gave them numbers as
They came in?
Yes.
Okay, then let's call it 3. Let's be consistent, better to be consistent with our internal flow than the external numbers you put on them. So this would be plaintiff's 3.
Yes, Your Honor.
Okay. Mr. Ryan, do you have an objection to plaintiff's 3 being made part of the record of this hearing?
To the extent it's not being offered for the truth of its contents.
Okay, it's admitted.
Should I hand that to the court reporter?
Nope, I am the keeper right now. Or maybe I just got copies of, we'll do that later. He'll leave with the exhibits.
Okay, Mr. Smith, what do you use the property for? Why do you want to occupy this real estate?
It's twofold. We have a mechanic shop there, and then we also do bus sales and vehicle sales.
Okay, so you make money off this property?
Yes.
How much do you pay a month in rent?
$7,000.
And since litigation began in Clayton County, have you continued to pay your rent?
Yes.
How are you paying your rent?
Into the registry.
The 7,000 rate that you're paying, when was the last time that that amount increased? If we go back to December of 22, when the inspection happened and you're interacting some with the Hickory people, what was rent back then?
That would have been of 23, Your Honor, when I was engaged with Hickory.
Yes, 23, correct. But what would rent have been back in 23?
7,000.
So rent has not gone up since 2023,
It has not.
or at least you haven't paid more rent than $7,000 a month since 23.
I have not.
Okay.
Is your business profitable?
Times.
Would you want to remain on the property if it was not profitable?
No.
No questions at this time. I would like the opportunity for redirect if necessary.
Of course, I'll turn back to you after cross is complete. Mr. Ryan?
Give me one moment of indulgence, Your Honor. Thank you for your indulgence, Your Honor. Hi, Mr. Smith.
Good morning, sir.
Mr. Ryan, I represent Mr. Dunn. Just a quick handful of questions for you.
I'm not going very quickly.
Sorry. VBT has not filed federal tax returns for the last 5 years, correct? VBT is not exempt from filing federal tax returns, correct?
No, sir.
Sitting here today, do you know how much money VBT made in 2023?
I don't.
Sitting here today, do you know how much money VBT made in 2022?
I don't.
What led you to say it was profitable then when Mr. McMaster was asking you about your business? If you don't know how much it made, how do you know if your income was greater than your expenses?
When I responded to him talking about at times, there were some months when I looked and when I took in what we took in and our expenses that we made money, but I don't know the total picture because I don't have that.
Who handles it?
My wife.
Would she share with you if you were hemorrhaging money or making millions of dollars, or it's just, you don't care?
No, she would, but I don't know that number.
Okay.
No further questions, Your Honor.
Got it. Mr. McMaster, do you have any redirect?
Yes, Your Honor. Mr. Smith, you stated you don't know the number of what you make on the property running the businesses, but you did say to the court that's profitable. So do you make more profit than $1
I do.
per year?
Yes, sir.
Do you make less than 1 million per year
Net?
net?
Yes.
Can you give the court a range that you're confident you net per year?
Between both businesses or just VBT?
Any business that operates on the real estate property at issue in this case.
Couldn't give you an exact number.
I'm not asking for an exact number.
I don't know the exact number, but I am confident. Well, let me explain. One of the reasons why I don't know that exact number is because we pay ourselves, or I pay myself, a minimal salary because we're constantly trying to put money into the business.
I see my error. Let me correct. What do you pay yourself salary from running these businesses per year?
For VBT, about 100,000.
No further questions, Your Honor.
All right. Any recross?
No.
All right, Mr. Smith, thank you. You can step down.
Thank you, Your Honor.
Careful. And leave any paperwork there. Lawyers will sort that out. Mr. McMaster, any other witnesses?
No, Your Honor.
Okay. Anything else from your side on these issues? We'll have argument in a minute, but any other evidence you want to tender?
Yes, Your Honor. I would like the court to take, and to be honest, it sounds like you already have, but just so we're all on the same page, I would like the court to take judicial notice that there was a pending dispossessory action in Clayton County between the same parties, and it is now pending on appeal in the Court of Appeals. And I can get you those case numbers.
Well, let me just ask Mr. Ryan. I mean, I'm aware of that because people have talked about it. I don't know that I can take judicial notice of proceedings in at least parallel courts, other superior courts. At the Court of Appeals, I might be able to, but I don't think there's a contest about that. Mr. Ryan, you're not disputing that there's a dispossessory action that has been long fought in Clayton.
There is a dispossessory action pending.
Okay, got it. I'm aware of that. So if you want to rely on that in some way in making your argument, no one's going to say that's not in evidence.
Okay, and then also I'd like the court to take judicial notice that it is docketed and pending on appeal at this time.
With the Court of Appeals?
Yes.
Okay, I had heard that it had been appealed.
You had heard? Ed?
Yes.
Okay. And that's it. I just want the court to take judicial notice of those facts.
Okay.
No evidence at this time. Thank you.
Mr. Ryan, any rebuttal presentation?
No, Your Honor.
Okay, then I'll view the evidence as closed and we should have a further conversation about, you can give your summations and we can talk a little bit more about the law, the conversation that we started on the 3rd. And I'll start with you, Mr. Ryan. You'll get to open and close if there's something you want to say in response to what we hear from Mr. McMaster. But why don't you front load it? Since there's no jury, you don't need to save your killer argument to the end, because I would then turn to Mr. McMaster if he said, could I say something about that? And say, of course you can.
I want to start by addressing the stranger doctrine, because I think that is in many ways a linchpin from the legal arguments here that Mr. McMaster raised last week in his motion for directed verdict, or more appropriately, the civil procedure code when there's no jury. And we left last Tuesday with a directive to find some cases with where a tenant that dealt with a tenant allegedly tortiously interfering with a landlord. Ms. Eith and I can say that we have scoured the records, and the only case that involves tortious interference where the tenant is allegedly the interferer is the case that I referenced
last
week, the Tedford case. And that is a case where a sublessor's lease expired, but remained in possession and was paying rent, and a landlord sued them for tortious interference with a prospective new lease, and the Court of Appeals affirmed the denial of a JNOV without explicitly referencing the stranger doctrine.
Okay. And when you say you couldn't find anything, meaning you couldn't find anything, or boy, you found some cases that were good for Mr. McMaster because they said, of course a tenant can't tortiously interfere because he or she sort of in this triangle of relationships of landlord trying to sell the property to someone else, which would result in the ouster of the tenant.
I mean anything, Your Honor. As an officer of the court, I can represent that we found nothing in this line of relationships.
Right.
Now, there are cases out there, and I can talk you through some of them, where the Court of Appeals has said that a landlord is not a stranger to certain tenant contracts and situations. One of those cases that I think is interesting and referenced in a few subsequent cases, even by the Georgia Supreme Court, is the Rendon case, which that was a case where a tenant alleged that it was attempting to sublease the property, and that sublease right came from the lease.
Sure.
And he was alleging the landlord was interfering with his ability to sublease when the landlord's approval was required to do that lease. And so there's, not only is there an interest in that sublease transaction because the landlord has the initial lease, there's straight privity in that situation.
Right.
So clearly a landlord who has an interest in the use of his property because he has the full bundle of rights with that property is not going to be a stranger in that situation.
Right. If our case were Mr. Smith claiming that Mr. Dunn was interfering with Mr. Smith's ability to sublet a piece of the property to Hickory because they wanted to do something with it, it's a completely different dynamic.
Completely different scenario. And that's actually been recognized, and again, it's in a one of your peer courts, so I don't know how telling that is, and it's in a different situation. It's a motion to dismiss situation, but Judge Scott in DeKalb County Superior Court in a Dev First Sports Academic LLC, and I have copies that I can.
Can you give me the citation to Rendon? You said
Rendon, yes, Your Honor. That is 213 Georgia App 333.
Thank you.
And it's a Superior Court case, so it's unpublished, but I don't know if I have a copy of the case. Which I can provide to Mr. McMaster as well. And this is a case, it's on a motion to dismiss, and a landlord is a situation where a landlord asserted a counterclaim for tortious interference, and the tenant moved to dismiss that on Rendon grounds, basically saying this landlord-tenant relationship, no strangers, etc. And Judge Scott in that case, again on different posture, recognized that Rendon doesn't stand for this overarching proposition that a landlord-tenant situation, full stop, means that all parties to that contract can never be strangers to other situations. So what you look at when you're looking at this stranger doctrine and how that's articulated, kind of one of the cases that everyone keeps coming back to from the Supreme Court, it's the Atlanta Market Center Management case, v. McLean, and that's 269 Georgia 604. And that's a case that really kind of fleshes out for the first time this idea of, not for the first time from the Supreme Court, but really kind of consolidates these Court of Appeals cases that have been coming from the years before and fully articulates what is happening in that situation. And it comes up with the idea that, it goes through that agents have been found not to be strangers. A supervisor is not a stranger to an employee contract, and third-party beneficiaries aren't strangers, and basically makes this statement that the idea that you must have a benefit or economic interest in the contract at issue. And that,
but if that's the test, doesn't VBT have an economic interest in the contract in the sense that, we have this business and we could lose the business, or at least our ability to practice this work on this land if Hickory and Dunn decide that they want the land free and clear of any tenant?
That is a good question, and the answer is no. Because, and bear with me, because the sale contract does not disturb or in any way and cannot disturb the contractual possessory rights from the lease. And in fact, that first sale contract was subject to those existing possessory rights. Essentially, VBT would be in the same position, and its position does not change one iota between Mr. Dunn as an owner and Hickory as an owner.
Got it. And it might change in ways that aren't contractual. Hickory would need to honor the lease. There wasn't a lease at the time, or at least not one that it had expired. So
it was expiring.
Yeah,
it was close to expiring.
Okay, but it didn't acquire it. And there's not a lease now.
There's not a lease now.
Okay. But had the lease gone through 2028, Hickory would have acquired it subject to the lease.
Correct.
And they couldn't modify that lease without VBT agreeing to it.
Correct.
And so they were buying knowing that we've got this thing on the property at least through 2028. They might have been less interested in renewing because they wanted to turn it into a fairground or whatever they were going to do. That's just the vicissitudes of being a tenant, is that you could have a new landlord who decides we're not going to be in this line of work anymore.
That's correct.
Okay.
And I think an even better articulation of what I was going for is found in the Mabra case, and that's 316 Georgia App 62. And the pin site is 65. And the quote there is, it recognizes that one is not a stranger to the contract just because one is not a party to the contract, and says those who have a direct economic interest in or would benefit from a contract with which they are alleged to have interfered, even though not an intended third-party beneficiary of the contract, are not strangers to the contract and cannot have tortiously interfered. So what we're looking at here is having a direct economic interest in or benefit from the contract that is being interfered with. And VBT did not have that in this situation.
Because their life was unchanged, its life, the corporate life was unchanged through that transaction, because any lease that happened to exist would carry over term for term, section for section, paragraph for paragraph.
Correct.
The anxiety that the transaction might create doesn't make VBT not a stranger. The fact that it might increase the risk that the new landlord would not renew the lease. That is just part of life, as opposed to, I'm not speaking, it's not a question, because the reality is, unless there was some guaranteed renewal, which would then have been part of the lease,
Correct.
which Hickory couldn't change without VBT's consent, then structurally VBT is in no different position. The lease expires on this date, and I'm going to be dealing with Hickory instead of Mr. Dunn.
That hits the nail right on the head. And in fact, we've heard no testimony or evidence, and I could proffer to the court that there was no discussions about extending the lease when Mr. Dunn was the sole landlord entity in the picture. So that just was the situation that VBT found itself in.
Okay.
And then before I dive into kind of the fact situation, Mr. McMaster brought up the malice provision in tortious interference and the elements there. And I think it's important to have in mind the definition of malice. And this one can be found in Schlossberg v. Giller, and that's 341 Georgia App 581. And the Court of Appeals in that case stated the definition of malice in this context is any act which constitutes unauthorized interference or interference without legal justification or excuse.
Malice has got to be the most overused word. I mean, it means something different with murder. It means something different with libel. And what a poor word.
Poor word, and even the definition, I will admit, is a bit circular. Why, you know, but that is what the Court of Appeals tells us to do. So
they're the right words, because that's what the Court of Appeals
says, and that's what we are bound by at this juncture. And I think what that shows is it's kind of, I view it, when you're synthesizing this malice definition with this stranger concept, they're really two sides of the same coin. If you are not a stranger, if you have an economic interest, then you have a legal justification to be interacting. And when you're interacting in that legally justified way, you are not interfering. But if you are absent any of that legal justification, if you have no interest in the transaction being interfered with, it's not okay. And I think what it really comes down to is when you think about it from a common sense perspective, which the law does not always follow common sense, we know, finding that a tenant in this situation, when he is not directly affected by this transaction, can just do whatever he wants or whatever it wants to interfere and attempt to subvert a landlord's right to alienate his property as he sees fit, that sets up a potential litany of unintended consequences, with tenants getting to dictate how a landlord gets to use his land and use his property when they don't have that right. They don't have that stick in the bundle of sticks. That's the landlord's. And in a way, it would be encouraging or excusing that conduct and leave a person such as Mr. Dunn in this situation without a legal remedy for sitting around on this contract for 2+ years. And I think that transitions us into some of these other elements that are not in dispute. Can I grab the... Yeah. Now, I'm going to use a demonstrative as I'm walking through these damages based on what has been admitted in this case. This is not being tendered into evidence, obviously, but I wanted to give it to your honor so you can follow along.
Okay.
As to what he asks here. And I'll bookend this, but I'm just going to walk through kind of bottom up, and then we'll dive into damages again at the end. There's no dispute that there's evidence that has been submitted that Mr. Dunn has been damaged by this delay, right? We had $912,000 that he was expecting to hit his accounts on February 4th of 2024 that has not, and still has not, hit his account. He's had continued carry costs. He is in a markedly changed circumstance than what he was had this deal gone through, absent the interference.
So the big figure is what you get when you apply the rate of return that we saw from the, I think it was Merrill Lynch, some fancy portfolio, times the number of days, times what he would have netted had the closing gone through.
Correct.
And then you add on what you've already demonstrated. There were property taxes that were paid. There's insurance that's been paid.
Correct.
And that gets you to
it gets you to
just shy of $400,000.
Just shy of $400,000.
Has to be offset by the fact that, in theory, he'll be getting some of it. I think he got directly. Some of it's sitting in the registry, but there's $7,000 a month.
Correct. That's 125 months of rent, and I believe if we're being clear, given we've continued now, we're at 26 months because that March was deposited into the registry.
Okay.
Of course, not in his possession yet, but technically.
Right. Well, but the cost of delayed performance has gone up as well.
Exactly. So that's how you arrive at the ask here, which is the $220,000. And that's without prejudice, and that's just in the compensatory damages. That's without prejudice to the 13611 attorney's fees that we haven't put up yet, if we get there, or the punitive damages piece. Now, there's also no dispute from the testimony from Mr. Costin or from mainly from Mr. Costin, that there was conduct from VBT through its principal, Mr. Smith, that was the cause of this delay. Mr. Costin directly tied the First Amendment and the fact that they haven't closed under the First Amendment to Mr. Smith's conduct, right? We heard Mr. Costin say, yes, I was willing to, I work with tenants on properties that I take over all the time. I've extended tenants before. I was willing to have those conversations with Mr. Smith and VBT, and one, VBT never had those conversations with me, didn't show any interest in that. In fact, what Mr. Smith did instead was tell me bad things will happen to me if I continue with this transaction, and appear unannounced at my offices, making my employees very uncomfortable in the process, pestering me after the fact, saying, you know, I was just going to do to you what you did to me. These are words that, while, yes, there was testimony from Mr. Costin that Mr. Smith on the November 27th date said, oh, no, that's not a threat. But as Mr. Costin said, those are words that people
they were what they were. They prompted the would-be buyer to say, I'm not going forward with this deal if that's your tenant.
Correct.
And he's entitled to do that. And that is thus a cost to Mr. Dunn.
It is.
Because if he wants to consummate the deal, he needs to figure out how to get VBT not present, which has led to dispossessory lawsuit, et cetera.
Has led to dispossessory, has been an ordeal. And there is no dispute as to the second element here, that VBT acted purposefully and with an intent to, if not directly cause injury to Mr. Dunn, to get the property for himself. Very, very selfishly. I mean, that's been his stated intent this entire time, was to get the property for himself, to stop the sale to HREP.
Well, you say selfishly, I mean, I guess I could apply that, but it wouldn't be, I'm stealing the property.
Correct.
It would be to resurrect what he felt was wrongly taken from him, which was this option to buy. So it wasn't, I'm going to scare off Hickory and I'm never going to pay Dunn anything for it. It just was.
No, I'm just going to pay Mr. Dunn something that's a price that was negotiated 2.5 years beforehand.
Understood.
At a substantial discount that, has clearly expired, as we have already decided in this case. So that really gets us to whether there is improper conduct here. I think we've covered privilege, and I don't think there is privilege here, right? He is a stranger to this contract. He has no economic interest in this deal. It's different. And I think it's also important to look at, was VBT taking these steps, doing this conduct, whether it be threatening Mr. Costin when he applied, when he showed up to do that initial inspection, acting, we heard from Mr. Costin that, and from Mr. Bush, although that was secondhand, but from Mr. Costin, that Mr. Smith spent the December 9th inspection pacing the property, gesturing at the walls, at the fence, and kind of walking along and touching the fence as if, I don't really know how to describe that, just acting in a way that is not professional and not conducive to wanting to continue a relationship and purchase a property where that kind of an individual is present. Making repeated calls, showing up uninvited to the HREP offices, making people at HREP afraid, given that prior erratic behavior. This is not, and look, I recognize it was a quote unquote brief interaction that happened at the HREP offices, but it was a reaction that was compounded on, it was a visit that stood on top of the previous conduct that got, I think, a believable and genuine reaction from Mr. Bush. Mr. Smith, in his testimony today, admitted that Mr. Bush was visibly caught off guard when he was there. Because they don't, as Mr. Bush said, they don't have visitors at that office. This is an appointment type business. This is not a public place. This is not a Walmart. This is not even one of those office buildings downtown that frequently has lots of people walking through the lobby. This is a suburban situation. And I think the most important thing here is that he's refused to leave the property. He's just sitting there. He's still there. And he has no legal justification for that. His lease expired on March 1st of 2024. Full stop. And it's these actions, it's this action of the company in that way. And I think it's important to look at, and I expect Mr. McMaster to get up here and talk again about the landlord-tenant relationship and how that plays into whether we should talk about an economic interest or not, is that none of these actions, other than perhaps wanting the inspection to happen on a weekend so as not to disrupt his business, none of these actions are really being taken by VBT and its principal in its capacity as tenant. Right? You saw his intent at that time, his admitted intent at that time through correspondence from his attorney was as a competing purchaser for this property, right? He's not exercising, if there could be a legitimate basis for this, he's not exercising or talking to HREP as, hey, I'm the tenant here, I am interested in leasing the building. He's saying, get away from this property, I have the right to buy this property. That is outside and absent any legal justification. And I just think when we're looking at the witnesses that you have heard, Your Honor, there's a credibility distinction. Mr. Dunn was just trying to sell his building and has been dealing with this problem tenant now, this problem holdover tenant for who knows how long. Mr. Costin, Mr. Bush in particular, other than being an employee of HREP, has no real rub in this situation, has no reason to be dishonest here. And I think when comparing the testimony between someone who is trying to do the right thing, trying to exit his business, trying to benefit his family, versus a representative of business who can't tell you if he's made a profit, who admits to that his business doesn't file tax returns, there's a credibility concern there when weighing those witnesses' testimonies. I think when you take all of this together, you cleanly satisfy the 4 elements of tortious interference. You have improper conduct. You have purposeful action. You have a delayed contract performance, which satisfies the test under tortious interference, and you have clear damages. You have $220,000 in damages to Mr. Dunn. In looking at, I guess just to one last point, so we don't lose it, on the bad faith attorney's fees. To find liability for bad faith, intentional torts have an inherent element of bad faith to them. And I have a case site here for you. So Fertility Tech, that's a Court of Appeals case, 282 Georgia App 148 from 2006. Direct quote, because tortious interference is an intentional tort, which indicates bad faith, the award of that claim authorized an award under OCGA 13611. The intentional conduct underpinning the intentional tort, that same conduct can underpin a finding of bad faith authorizing an award of attorney's fees under 13611. And for that, I will go ahead and close and allow Mr. McMaster.
May it please the court, Your Honor. I'm going to start from the realm of common sense because I think that'll get us where we need to be a lot faster from a optics standpoint. So we have 2 parties here, one of them fighting for their business that essentially feeds their family, allows their kids to play soccer, and the other party owns $1 million property, gets $7,000 a month for essentially doing nothing on the property, who's upset that they can't take their $1 million and liquidate it out of the property and invest in their Merrill Lynch bank account.
But if it is that person's property, why shouldn't they be able to do that?
And that's a great question. I'll get to that. But what I want to do is draw the attention to the court of the law, the purpose of the law, and start at the common sense standpoint. So from an optics standpoint, we are in a justice system, and
But common sense and optics are different things. I would call what you just shared is, well, let's look at it from the sympathy standpoint, using your optics, which is someone trying to run a business and started with not much, has a successful business repairing buses and selling buses and supporting some family members, and this greedy landlord is trying to kick him off. When I understand the optics to be that the landowner, regardless of his background and his means, and whether he's trying to make sure his grandkids can play soccer, is simply trying to sell his land to someone else. And if all had gone smoothly, it of course would have been subject to the lease, which means life doesn't change for our bus repairman. I mean, it wasn't that originally how this would work, but for the bus repairman throwing one of the big wrenches he used to repair the bus into that contract that would have transferred the land from someone who may have pulled himself up from his bootstraps to Hickory.
And I love the dialogue, Your Honor. We're in the right place, and here's where it's relevant. What I'm trying to convey to the court. They used these facts against my client. Some people showed up uninvited to his property, and he was obviously not happy about it, and he went for a walk, and he did some pacing. My client called individuals responsible for this multiple times. They didn't respond to him. Again, he's probably not happy. Goes to their office to speak to them, sits in the reception room for 5 to 10 minutes, and then leaves when they tell him the guy he's looking for isn't there. Okay? That is very reasonable from my client's perspective. And I think if the court can see the big picture, that's not malice, that's not even unprofessional. That's human, and that's proper, and that's how we want people to behave in these circumstances.
So what I'm hearing you say, if I'm following you, is that basically there wasn't interference that happened here. The things that about which defendant is complaining don't rise to the level of interference. I don't need to reach your argument that actually there was privilege here. It really doesn't matter if there was privilege, because what Mr. Smith did wasn't interfering. He got out of the way of these people when they came to inspect, walked on effectively his property. And when he was confused as to why they're here and couldn't you give me the courtesy of alert that you're coming, and I'm not getting a call back from these people, then I gotta go to your office to talk to you. And when the guy wasn't there, he didn't throw something through the window or take his shoe off and wave it in the air. He said, just let him know Emmanuel came by, and he left.
Yes, Your Honor.
Okay.
Furthermore, HREP is not a party to this case. Another common sense point, the facts as I see them are that HREP tortiously interfered with my client's contract with Mr. Dunn.
Not the suit that your client brought, but okay.
Absolutely, Your Honor. And where's HREP's tortious interference claim against my client? And this is a common sense point. And then intuitively we know, okay, this is odd, because the same fact showing tortious interference for one side could show tortious interference on the other side. And this is a scenario where the law actually does make sense. And the reason it doesn't work is because we have this stranger doctrine. No one's a stranger here. The purchase agreement between Mr. Dunn and HREP has my client's lease agreement attached to it as an exhibit. And after my client filed a lawsuit, that is when the amendment occurred. And what I was trying to think of on my drive here today, this case happened way too quickly, but I'm not here for therapy. I was trying to think, what's a scenario where we have someone who is far more of a stranger to a contract than my client is to this one, yet we can all agree there would be no tortious interference claim available. And so let me give you a hypothetical. Suppose you have a guy by the name of Marty living in a home, and across the street, his neighbor is going to sell the home. And the buyer, his name is Biff, and he says, hey, Marty, I'm going to buy your neighbor's home, but I'm not going to buy it if you continue eating breakfast every day. And Marty says, you know what? I never eat breakfast anyway. And Biff says, I bet you're too chicken to eat breakfast tomorrow, Marty. Marty wakes up the next morning and says, I'm going to eat breakfast. I don't care if Biff's contract says he's not buying that property if I eat breakfast. And Biff sits back and says, keep eating breakfast, Marty. I'll see you in court. Marty says, yeah, I'll see you in court. Marty continues to eat breakfast. Can Biff go haul Marty into court and say, look, you're tortiously interfering with my contract because my contract's contingent on you eating breakfast? Could Marty's neighbor say, hey, Marty, you're tortiously interfering with his contract because the buyer won't buy it because you keep eating breakfast. Absolutely not. And the reason it doesn't work is that privilege element. And if you go to the case law, I think it's the McLean case, maybe one of the subsequent ones. I know you cited one in the summary judgment motion, West Firm PC, what have you, but they actually commingle those elements. I don't think they should have, because I think they can exist separately. But the point is this: at the moment, Biff said, or made as a condition, Marty's behavior, Marty was no longer a stranger. He's not a stranger. Now, let's go to this case. This case is even further removed because we have rights codified and a lease. So we have a lease agreement that goes beyond the closing date that my client is a part of with the seller. So he has rights as a tenant. I primarily do landlord-tenant law. That's my focus. I like it. It's very rigid. And people ask me all the time, they say, tenants have no rights in Georgia. And I say, no, they have a lot of rights in Georgia. Tenants just don't know how to assert them. Let me help you out with that. And you can go to the code section 44-7-50, 44-7-2. That is the landlord-tenant code, and it outlines the rights of a tenant before the landlord can come change your locks. And in addition to that, every lease or every contract has a right to breach. You have a right to breach a contract. That's a right. So sure, you may not like it when someone breaches. You may be entitled to damages when someone breaches, but it's still a right. It's not a tort. A breach of contract is not a tort. So my client has rights as under the contract. He has a right to breach the contract. He has a right to have an executable writ of possession under the landlord-tenant code before he has to leave. He has a continued right to stay there on appeal, and that's in the landlord-tenant code, saying just pay into the registry, you get to stay. Those are all rights. So when we step back and we look at this and say, you know, why isn't there a counter tortious interference of a three-way thing going on? It's because they are interwoven. These relationships are interwoven, and there are privileges attached to my client. There are privileges attached to everybody here. This is not a tort case. Going to the other elements, Your Honor. I believe I already addressed malice regarding my client's behavior. Another issue regarding I guess it attaches back to the privilege, the stranger doctrine, is my client does have a legitimate business interest. He has a legitimate financial interest. Aside from his feelings about someone purchasing it, were you going to speak, Your Honor?
Well, yes, because where I'm not connecting with that focus is not because I disagree that your client has a legitimate business interest. He has a business in which he is interested. It operates on the land he has lawfully leased and to which he is entitled, subject to the conditions of the lease. This transaction would have left that undisturbed, zero impact on his economic interest in the land had the original sale gone through. But it didn't go through, arguably, because of actions that interfered with that deal. And so let's not get into did he interfere or not and is breach a tort. Help me understand how Mr. Smith's, VBT's economic interests in the land were in any way impacted by the first purchase agreement.
Your Honor.
Rent didn't change, duration of lease didn't change. They couldn't change legally without your client agreeing to them. And so, of course, no steps were taken to change any of those conditions. Let me ask it in a different way. If in the dark of night, Dunn and HREP had consummated the deal and the transaction occurred, and Mr. Smith didn't even know it had happened. And then he gets an email saying, hey, from now on, pay your rent to Mr. Costa. Here's the address. What claim could he have brought in court saying, wait, my lease rights, there's been a breach of the lease?
And that's a great question, Your Honor. Let me get this while it's on my mind. He had, one, the interest in purchasing it, which he thought he had a right to, and he sought counsel for that.
Okay.
Two, there's no evidence to support that this thing didn't blow up before my client even knew of all the terms of that lease. This thing blew up December 8th. It was filed in Clayton County before it was transferred here. They came to the property November 20th. There's no evidence that my client knew what the heck that agreement said.
But that's not my question. My question was, if Mr. Smith woke up one day, went into work, and there was a notice in the mailbox saying, from now on, your rent payments go to HREP because we've acquired this. We bought it from Mr. Dunn. Setting aside, which has proven to be an unsuccessful claim, that he had this purchase option. Set that aside. What claim would he have to say my economic rights have been impacted or the lease was violated or anything like that?
So I get this question all the time from tenants.
And what do you say to them?
I say, only the owner of the property can be your landlord. And when generally the default rule under Georgia law, when someone purchases your property, is you are now a tenant at sufferance, because your landlord you no longer have a landlord-tenant relationship with who your leaseholder was. So this new owner has now put you in a situation where you're a tenant at sufferance. Fortunately, you have this 90-day foreclosure law where they're entitled to certain.
Okay, but that's a more complicated answer. What we know is that the way this deal was structured, the lease would have traveled with the land. And so I'm not saying Mr. Smith necessarily needed to understand that on day one, but had he hired counsel or called you, hey, you're that tenant lawyer guy, what's this deal? And you would have said, well, I need to see the purchase agreement. Well, look at that. HREP purchased this land subject to your lease. You've got a new landlord because there's a new owner of the land. You're not a tenant at sufferance. I believe you're still subject to that lease. If I'm correct with that assumption, then again, what's changed for your client economically other than he strokes a check to HREP rather than Dunn?
Right. So once you're a tenant at sufferance, if HREP says you're now my tenant, you're still a tenant at will, meaning they could give you a 60-day notice and you're out after 60 days.
How? If the lease still had a year left, the lease with Mr. Dunn had a year left when this transaction occurred, and the purchase agreement says we are acquiring this land subject to the lease that you have on it with your tenant. Because you mentioned, VBT's mentioned, they're in an attachment to the purchase agreement. If that had gone through, then you're saying legally, I don't know this area of the law like you do. You're saying legally the impact of the purchase is that it extinguished the lease?
Unless they adopt it, but
Okay, but they did.
It never happened.
Well, because the deal didn't go through, but I thought, and maybe I've been misapprehending it, that the original purchase agreement included HREP adopting the lease. Correct?
Yes.
Yes. Okay. So if yes, then isn't it true that had Mr. Smith woken up one morning and there's the monthly bill, but it's on HREP stationery rather than Dunn stationery?
I see.
He's just paying money to a different landlord, but his business is intact and his property interest in this land is unchanged. There's just a different owner.
Right. I get it, Your Honor. So here's what I would say.
Well, but not only don't you get it, but isn't that what would have happened if the purchase agreement had gone through as originally negotiated?
I don't know what would have happened.
Why do you say that?
I would have to look at it in detail right now.
Okay.
I don't want to waste your time. I could look at it right now.
No, I don't mean to put you on the spot, other than that I sure thought the way it was structured and didn't hear you push back on that, is that if the deal had gone through, actually nothing changes for VBT except there's a different landlord in place.
Right. I see, Your Honor.
Which is going back to my original question is what's his economic interest in this transaction? Because nothing his rent doesn't go up, the duration of the lease doesn't change. And then you suddenly said, no, he's a tenant at sufferance. I don't think that's how it would have worked.
Right, I see, Your Honor. So, and it's getting convoluted in my mind. So I want to be, let me address his interests. And because if we go down the financial, what's the net result difference, then you might be right. Net result, had communications been proper, maybe my client would have said, oh yeah, let's do it. I don't know. But what happened was
But even if there were no communication, and I'm sorry I keep interrupting you, but yeah, I think this is the heart of the case.
Okay.
Let's say there were no communications, because I don't think Mr. Dunn was obligated to tell, I think it was the right thing to do. And I think Mr. Dunn waited too long and kind of dumped it on him and probably soured whatever dynamic was going to be in the three-way dynamic, because, oh, by the way, I entered into this agreement. But he made the decisions he made that he's free to make because it's his land. Let's say there had been no communications at all. It was a bolt from the blue to Mr. Smith that Mr. Dunn no longer owned the land. It was HREP. And so, who are you? I'm TJ Costin. I'm your new landlord. And here's your invoice consistent with the lease agreement that is unchanged. Let's say that's what happened. What is the impact on VBT's economic interest?
It's twofold. Well, economic interest, based on your scenario, it's onefold.
So really no folds, but it's one thing.
One thing.
Okay.
In my client's mind, he was out his opportunity to purchase the property because he thought he had been working with Mr. Dunn to purchase the property.
Okay, I hear you on that. And if I conclude that that's a illusory economic opportunity, then I'd be in a position of saying there was no economic impact of that transaction. Yes?
Arguably, yes.
Okay.
Yes. But what we get back into is privilege. We still don't get away from privilege because he does have the right to choose who his landlord is. We all do. He has the right to say, I don't want HREP to be my landlord. He has.
Which he would exercise by leaving the property? He doesn't have veto authority to say, well, Mr. Dunn, I'll let you sell it, but not those HREP guys. They wear quarter zips and loafers with no socks. They're not, I can't be on their property. Sell it to someone else.
Well, he had an interest in discussing it and then making an analysis and make a decision for himself.
Okay.
He never had that.
Okay.
And I had another point on that.
I'll stop interrupting, I promise.
Okay, no, I want to get this all ironed out. Getting to the truth is what we should all be here for, so no, that's great. Okay, I'll move on, Your Honor. I guess at the end of the day, the point, aside from the economic interest, is we still don't get away from privilege and we still don't get away from the stranger situation. Because to me, the heart is a stranger situation. That's what caused the blow up. The other major point is the calculation of damages. First of all, Mr. Dunn still has the property. In my view, the Merrill Lynch numbers cannot possibly go into the calculation. And that is because this is a tort. And under OCGA 51-12-9, the code states damages which are the legal and natural result of the act done, though contingent to some extent, are not too remote to be recovered. However, damages traceable to the act, but which are not its legal and natural consequence, are too remote and contingent to be recovered. We had TJ testify that essentially his response and testimony indicated he didn't even think about putting money into a Merrill Lynch fund The the testimony by Mr. Dunn was that he never communicated his Merrill Lynch fund to Mr. Smith. If we open that door from a common sense standpoint, we open the floodgates to have every damage claim be amplified by savvy investors. And so I would say at this point regarding those damages, those are the effect of a third party. That's Merrill Lynch. That's the effect of separate actions by Mr. Dunn.
What's the rate of return that I should apply then? I don't think you'd argue, I hope you're not going to argue, it's just the flat dollar amount. If the deal would have netted Mr. Dunn, I think whatever 960 minus 48 is, $912,000. Certainly that grows in some way. I guess it could shrink. He could have put it in the bad Merrill Lynch account that had an annual rate of return of -5. I don't think you'd argue against that one. You say, yeah, that's actually, we like that one. But it's not a 0% rate of return. He's anchored it in some facts. This is my account. This is where I would have put the money. So I don't know that it's speculative. But what would you advocate for a rate of return?
Well,
because he certainly hasn't said, I'd put it in a sock. And that's a decision that an investor, it's not an investor, but someone who would have, the landowner who sells could say, I'm just going to put the money in a sock.
My argument there, Your Honor, is it's not a legal and natural consequence. And they built that into the new contract. It has increased purchase amount in the
that the delay would result in a higher and higher purchase price for Mr. Dunn.
Correct, Your Honor.
And you don't think he's entitled to explore collecting damages because he could demonstrate that, yes, there's the acceleration of a low percentage, but my goal was to get the money out then because I'm a good investor and I want to redeploy my assets in a more productive way. Land value grows at 5% a year on average in Clayton County. And because Merrill Lynch does well, I know I'm going to get 10% a year. Why don't I have the right to move from a 5% to a 10% yield? And you've interfered with that. I ought to be, those are damages to me. I guess I don't see how that's stretching 5, 12, 51, 12, 9.
It's the second sentence, because those are not legal and a natural consequence of that breach. And let me give you another example. You could extend this to any tort. You could extend it to car accidents. People are going to come in here and start saying, well, here's what I could have done with that money if I didn't have to buy that wheelchair. That's not the calculation for damages, because it doesn't flow from the tort. It's not proximately caused and it's not foreseeable. Hypothetically, the calculation could be under contract law, which I think we're probably close to, but they still have a contract and they accommodated for that with their balloon increase or increase every year that the sale doesn't occur. But let me go ahead and read you OCGA 13-6-2. It says damages recoverable for a breach of contract are such as arise naturally and according to the usual course of things from such breach and such as the parties contemplated when the contract was made as the probable result of its breach. So even if we use the contract definition for damages, no one contemplated the Merrill Lynch deposits. My client didn't contemplate it. The HREP didn't contemplate it from TJ's testimony. Mr. Dunn never communicated to my client. He testified to that about the Merrill Lynch investments. So they were never contemplated.
Not contemplated by your client, or I don't know the relevance of what Mr. Costin might be thinking Mr. Dunn's going to do with his money. But don't we have evidence what Mr. Dunn contemplated to do with the money that he was prevented from obtaining because of the alleged tortious interference?
Great question, Your Honor. And if you look at the code, it uses the word parties, plural. So it says such as the parties contemplated, where one person keeping a secret wouldn't fall into that category, or keeping it in their back pocket, or just forgetting about it. That does not satisfy the parties requirement.
Okay.
So that's it, Your Honor. In closing, I think under no set of circumstances can my client be deemed a stranger. And under no set of circumstances can this Merrill Lynch portfolio be considered damages, whether tort or contract. And even if the court wanted to consider that itemized list of other damages, my client's rent covers that amount plenty. In addition to the fact that defendant still has the property, the defendant still intends to sell the property, and no one's shown that the new amended contract has been amended again or the parties agreed to dissolve it. So in my perspective, my client's perspective, and hopefully the court's perspective, the defendant was never damaged in a way that's compensable for a tortious interference claim. Thank you.
Thank you. Mr. Ryan, do you have any brief
Very brief.
rebuttal?
Very brief. I just want to talk about 5112.9 and provide a perspective.
Just pulled that up.
Right.
Okay. Which doesn't say parties. The parties
No,
language
the parties
is in.
language is in the contract,
Yeah.
and this is not a contract. This is a tort.
Understood.
Right. So damages that are legal and natural result of the act done. Take a car wreck case. That is contemplating, if I rear end you, it is a legal and natural result that you may be injured, not that I knew and foresaw. I mean, this is, glass, gosh, it's been a long time since law school, but the glass plaintiff rule, right?
Eggshell skull.
Eggshell plaintiff, right? It's not that I knew that me rear-ending you would cause you $500,000 of damages. That's I think the disconnect and the false equivalency we're dealing with here. It is a legal and natural result of not closing on February 4th of 2024 is that Mr. Dunn did not get the proceeds of the contract.
Right. He's out $912,000.
He's out $912,000. And in fact, I think I could get up here and argue that we are, in a way, cutting our damages short by resolving this issue now. This First Amendment expires on December 31st of this year. That contract could not close. Mr. Dunn next year could be up here saying, I'm out $1 million. And those are my damages, but we're not doing that.
Right, because HREP walked away.
Right. Those could be the damages in this case. Instead, we're looking at delay damages from the delayed performance. And we have a clear, and I think Your Honor recognizes, non-speculative line that was set up by Mr. Dunn's testimony. He's received money like this before. He has a practice and a pattern for how he utilizes those funds. He invests them in these Merrill Lynch accounts. And yes, the last 2 years in the stock market you just look at the S&P average, it's been a little absurd. There've been very good returns. And he had the benefit of that. In fact, his accounts that he would have put this in, I believe, have underperformed the market average if it had just been a straight S&P, spider ETF. So foreseeable, reasonable connection, rational, recoverable. Thank you.
You're welcome. I want to thank both sides for coming back a second time. I'm sorry we weren't able to wrap things up during our first session, but you guys were on point today. I have before me all the evidence from the two sides and the legal arguments. I will take this all under advisement. Anything else Mr. McMaster on behalf of VBT.
Regarding the counterclaims, because I believe that we have another motion going today from them.
What motion is that?
The motion for prevailing party contractual attorney's fees for the being prevailing party on the summary judgment motion and the dismissal of the affirmative claims. And I understand you have a 1 o'clock sentencing, Your Honor, so.
Right. So it doesn't sound like we're doing that today.
Is that the rest of your day, Your Honor?
The rest of my day is, I do have a plea at 1, and then I have something at 1:30, et cetera, et cetera. So I had forgotten that there was yet another motion for yet more fees on the civil side. So we will need to handle that. Were there other things you were wanting to address?
There were threshold questions to that motion, meaning the court shouldn't even hear it unless they jump through these few hoops.
Okay.
We could hear that argument today if you'd like. We could put it all another day. That's fine too. As to this, I have nothing left, Your Honor. I said what needs to be said.
Okay, got it. Mr. Ryan, did you have anything else in connection with your client's counterclaims?
Yes, Your Honor. Well, not for the substantive portion, I believe, since you're taking under advisement liability under tortious interference and 13611, if the affirmative on both of those, we would be back to do fees on that count. Unless you would, because we reserved putting up my witness testimony on fees pending the substantive.
Correct. So if I find liability for tortious interference and then for 13611, we do have to meet again anyway. There's also punitive damages floating around out there. I don't know if we'll work through that. But since we'd have to hear about that, if that's where I land, I guess we could just hear a whole lot about fees and handle the other motion as well, the prevailing party fees motion.
Sure, and I'm not sure based on
Is that something that requires a hearing or is it a pleadings based?
on the prevailing party attorney's fees?
Yes, sir.
Well, we do have a few additional fees which we could supplement with a supplemental affidavit. I believe, and Ms. I can correct me if I'm wrong, but I believe if you're going to award fees that Mr. McMaster and DBT have a right to cross-examine on reasonableness.
Okay.
So
I'm not looked at it. I just, off the top of my head, I don't. I know with 91514, which is not what you're proceeding under.
Right.
If I am contemplating an award, there must be a hearing. And so I'm assuming it's similar in this space.
Yeah, from the statute, no, and generally speaking, when I handle this is in a jury situation, and so the jury is deciding that after coming back with a verdict.
Yep.
One way or the other.
Okay.
But I'm not sure what the threshold issue Mr. McMaster was referring to about entitlement to prevailing parties attorney's fees, given the brief response he filed. So I don't know if that is something that we can handle now. Seems to think that was, but I'd be happy to take that up briefly.
So I'd rather just address it all at once, since we're going to need to reconvene again. I'm not going to give you a date this time. I'm going to want to rule on the counterclaims. And in that ruling, I can let you all know when we're getting back together for whatever might be left. Okay?
Thank you.
Thank you.
Thank you.
Thank you.
Mr. Ryan, did you want to go ahead and order the original date?
No, hold off.
Fine. Mr. McMaster, did you need a?
We don't need to order it today, but we do want to pay you for today and we may want it in the future. Can I just email your office?
Yeah, absolutely.
Okay.
Sounds good. And we're off record at 12:47.
Thank you.
Thank you.
Sorry, Your Honor, that's a habit.
No, I'm glad you said it. It's all good.
And you'll invoice our office for the appearance fee, yes?
Yes.
Okay,
yes.
fantastic.
I submit everything to them and then the office folks.
Sounds good.
handle it from it, yeah.
We'll look for it and pay.
I'm in the trenches and they do all the numbers. So hopefully we'll see it here.
Will you bring the furry things for the lawyers?
We will.
Good.
We're very.
Okay.
Where's that exhibit that you? In there?
It's on there.
Oh.
Will you all should the court reporter take, plaintiffs 3? Did you take exhibits last time too?
I did.
Great, yes, take that. That'll complete the record.
Well, thank you again, Your Honor, for squeezing us in between your busy criminal day.
Not a problem.
And everybody have a wonderful weekend.
Okay, folks, it's a little after 1 and we are supposed to handle a plea for Mr. Hardison at that time. So if people could power on their cameras, there's Mr. Hardison. We will add him. Here is Ms. Wood. We will add her. We can remove the witness. The super exciting tortious interference with contract rights hearing is over, so we don't need that. We are, I think, ready to move forward. Ms. Rivers, are you able to hear us?
Yes, I am. Good afternoon.
Good afternoon. Then let's dive into it. Mr. Hardison, well, let's call your case first. It's 24 SC 08 versus Hardison. Mr. Hardison is represented by Ms. Wood, and we have Ms. Smith here in court handling things for the state. Mr. Hardison, are you able to hear us?
Yes, I can hear.
Great. Mr. Hardison, you have the right to be here in court in an open public space, but you can waive that right and appear from wherever you are right now. Is that what you choose to do?
Yes, sir.
Okay. You also have the right to have Ms. Wood, who is appearing virtually, by your side, but you can waive that and agree to go forward having Ms. Wood appearing from her location while you appear from yours. Is that also what you're doing?
Yes, sir.
Okay. If at any point during our conversation you want to speak privately with Ms. Wood, just let me know and you guys can hop off and get on a cell phone, or I can put you in a breakout room, whatever it is that makes the most sense. Will you do that?
Yes, sir. That sounds good.
Good. Ms. Smith is about to put you under oath, after which she will ask you questions about your rights and about this case. You need to answer those questions truthfully and completely. You also need to be ready to ask questions of your own if you have any. And I'll only know that if you raise your hand or say, excuse me, so that we can stop and make sure your question is answered. Will you let me know if you've got questions?
Yes, I will.
Okay. Are you about to move to a new location, or are you going to be moving around the whole time?
No, I just moved to a different location.
Okay, great. Ms. Wood, was there something you wanted to add?
I'm so sorry to interrupt. I just wanted to flag. I don't know if this makes a difference. This will be, since we're just pleading to 2 misdemeanor traffic offenses, it will be a no-low plea.
All right, we should be back. Can you hear me, Ms. Wood?
Yes, Judge, can you hear me?
Yes, can hear you fine. We have back-to-back things, and I think the 1:30 just kicked this off. I had asked this to be extended till 2, but here we are. You had just started to say something. You said, I'm sorry for interrupting, and I was going to say no problem, and then you stopped talking, but you didn't stop talking. The system went down.
Yes, Judge, I just wanted to flag that this is actually a no-low plea. That makes a difference for licensing purposes. So just wanted to let everyone know that.
Got it. Okay. It is a plea to, we'll learn from Ms. Smith, all the counts, some of the counts, but it's a no-low plea. Understood. All right. Ms. Smith, when you're ready.
Yes, thank you, Judge. Mr. Hardison, can you hear me?
Yes, I can.
Okay. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Claudine Courtney Hardison.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
33 and some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Hardison, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 days to serve 2, commuted to time served?
Say that again?
Yes, 5 days to serve 2 with,
5 days.
yes, to
Not
serve.
weeks, months, years, 5 days.
Yes,
To serve 2 days.
yes,
And then,
commuted to time served.
okay, and what about the 3 days that are left over?
They'll be commuted to time served.
Okay.
Do you understand that that is the negotiated plea from the state in defense?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
It is a plea because it's nolo. I think technically it's not a guilty plea, and it will appear on your criminal history, but it's going to have a different impact than if you were pleading guilty. And that doesn't change anything we're talking about. It's going to function a little bit differently in a way that's favorable to you, Mr. Hardison, that it's a nolo plea.
Okay, got it.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes, ma'am.
Are you currently on probation?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by pleading guilty to these charges?
I am.
Mr. Hardison, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 24 SC 006442, how do you plead to? And for the record, Your Honor, count 1 will be no applause by the state. Mr. Hardison, how do you plead to count 2, reckless driving, and count 3, failure to obey a stop sign?
No.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Sorry, what was that? Hold on, I'm not missing. There we go.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal from your guilty plea conviction, but if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that must be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Okay. Thank you, Your Honor. If this case were to go to trial, the state would have shown that on January 22nd, 2024, officers of the Roswell Police Department were dispatched to the intersection of Lake Crest Drive and Lake Crest Terrace in Roswell, Georgia, also Fulton County, on a suspicious vehicle call. When the officers got there, they saw the suspicious car that was described by the caller leaving the subdivision when they were coming in. When the driver spotted the police officer, he began to accelerate and left the subdivision. At this time, Your Honor, the police officers turned on their lights to pull over the defendant, who was identified as the driver of the car. However, the driver continued through a stop sign, and while he was passing through that stop sign, someone was walking along that same road. He was not hit, but he was pretty close to the car that the driver, Mr. Hardison in this case, was driving. At this time, the officers did lose visual of that black Hyundai that the defendant was driving. However, after they canvassed the location and turned into a new subdivision that was not the one they initially reported to, they were able to spot the car again and the two individuals that was occupying it. When the officers got to the car, the defendant was identified as the driver and was arrested for the charges we have in front of us today. And those are the facts of the case. Regarding the negotiated plea between the state and the defense, again, the state will be no crossing count 1, which is fleeing or attempting to elude. But regarding charges 2 and 3, the state will be recommending a sentence of 5 days to serve, with that commuted to time served based on the 2 days that he's already spent incarcerated for these charges. And that is all from the state.
Okay. This is the first time you've recommended just days, which is fine. Why not? What I have in Odyssey is that he served 3 days, but 2 or 3, why not just say 3 days to serve as opposed to a higher number? Where'd the 5 come from?
It was just a number that we put in for the recommendation. We don't mind 3 days, but it was just 5 days to commute to the time served.
Understood. Okay. But your review of the case is that effectively a time served with no supervision, no suspended sentence is appropriate.
That's correct, based on the no process we'll be doing for count 1.
Okay. All right. Thank you for that. Ms. Stallworth, thank you. Nope, it's Ms. Harvey. Ms. Harvey, thank you for coming back to join us. Do you have any criminal history information on Mr. Hardison?
Yes, Your Honor. 16 cycles out of Georgia and 1 cycle out of the state of North Carolina. He received first offender in 2020 out of Cobb County for financial transaction card fraud, and that case was sealed in 2022. And nothing further, Your Honor.
Thank you so much. Appreciate you helping out today.
Thank you.
One more question, Ms. Smith, then I'll hear from Ms. Wood. Mr. Hardison's case actually shows being on judicial hold, and it was pretrial diversion. Is this the case where, hey, I went to work for a pizza place and then it really wasn't a pizza place?
That's
or
correct.
They'd never heard of him?
Yes.
Okay, got it. Okay, Ms. Wood?
Thank you, Judge. So I just want to let the court know, this case, I first started negotiating this case with Ms. Davis, Rashida Davis. And part of my negotiations back then was that our position was that it wasn't truly a felony. It's a beautiful sunshiny day in Roswell, Georgia. As you know, they don't have as much crime as other places. So one could argue that the great officers in Roswell were, having a bit of a boring day. I will stand on that it was not a felony fleeing. They don't even turn their lights on until sort of like halfway in their pursuit. And while, Mr. Hardison did not fully stop at the stop sign, the pedestrian was not about to get hit. I'm confident saying that because it was a great distance between them. However, he is eager to put this behind him. We really appreciate Ms. Smith making this offer. He works full time. He takes care of his child, and we've been working towards a resolution for a while. So I appreciate the state's offer, and we just ask that the court accept it.
Okay. Mr. Hardison, what is your job?
I'm a manager at CVS and a server assistant at the Painted Park.
Server assistant, does that mean like you're a waiter?
Yeah, pretty much.
Okay, and at what place?
The painted part.
Oh, painted part. Okay, got it. So you're a manager at CVS. You basically have two jobs, and you have how many kids?
One.
A boy or girl?
Boy.
What's his name?
Carter Hardison.
Does he stay with you, his mom, someone else?
He stays with his mom.
Okay. How often do you get to see him?
Every other weekend.
Okay, well, good. Do you have any questions about anything we have been discussing?
No, sir.
All right, well, I find there is a factual basis that you didn't stop at a stop sign, and maybe we're getting a little too close to the gentleman who wanted you to be further away. This is a nolo plea. I'll accept it as such. Ms. Wood, can somewhat, well, I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one is forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Hardison, can we electronically sign your name to the indictment indicating your nolo plea to the two misdemeanors?
Yes, sir.
All right. Count one is being dismissed by the state. Count two, your sentence is 3 days to serve. You'll get credit for the 3 days you did serve. Count three, your sentence is 3 days to serve to run concurrently with count two. And that is it. Anything else, Ms. Smith?
Nothing further.
Ms. Wood?
No, Judge, thank you.
Mr. Hardison, what city do you live in?
Sandy Springs.
Sandy Springs. All right. Well, not far from Roswell. Good luck with everything.
All right. Thank you, sir.
Do you have any questions about anything we just did?
No, that was it.
Okay. Thanks, everyone. Have a good weekend.
All right.
Thank
Thank
you,
you.
Judge. See you Monday.
Oh, yes. So Monday is Johnson followed by Linzer. And I got your voir dire on Linzer. And I think Mr. Barber sent it in. I couldn't get an email to go to Ms. Shelton because her email address in the bar directory is not a valid email address anymore.
Okay.
So it seems like everyone is gearing up, and we got clothes for Mr. Johnson, and we've ordered up jurors. So guys, have a great weekend. Enjoy getting ready, and we'll gather Monday at 9 a.m.
Perfect. Thank you.
All right. Thanks, everyone. Thank you, Ms. Rivers. I think I can end this Zoom now, and we'll go from there.
All right, see you Monday.
Bye. Thanks, Ms. Simpson.
Have a good weekend, Judge.
You too. Bye-bye.